Let us pray. Almighty God, we willingly acknowledge you as the Supreme Being, most gracious and most merciful. Look down, we beseech you, on us who are members of the Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in the Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath or affirmation, announcements by the President.
Honorable Senators, I have granted leave of absence to Senator Foster Cummings and Senator Candace Jones Simmons, both of whom are ill, and to Senator Sophia Choate SC, who is out of the country. Honorable Senators, I have received correspondence from Her Excellency, the President, Christine Carla Kangaloo, ORTT, advising of the following temporary appointments in accordance with Section 44 of the Constitution. Mr. Sanjiv Boodhu, during the absence of Senator Foster Cummings due to illness. Dr. Deborah McPhee, during the absence of Senator Candace Jones Simmons due to illness, and Mr. Wesley Gibbings, during the absence from Trinidad and Tobago of Senator Sophia Choate SC. Honorable members, honorable senators, senators are required to take the oath. Could we all stand?
I, Sanjiv Boodhu, having been appointed a member of Parliament, do swear by the Bhagavad Gita that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Wesley Gibbings, having been appointed a Member of Parliament, do solemnly affirm that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Dr. Deborah McPhee, having been appointed a Member of Parliament, do so swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Honorable Senators, former Senator Mr. Stephen Grease passed away on Friday, March the 27th, 2026. I now invite members to offer tribute. The Honorable Leader of Government Business.
Thank you, Mr. President. Mr. President, I rise to pay tribute to former Senator Mr. Stephen Grease, who departed this life on the 27th of March, 2026. Mr. Grease was a former independent senator in the 11th Parliament and was appointed on September 23, 2015, where he served for 3 years, from 2015 to 2018. He was born on the 6th of February, 1954, and raised in Pepper Village, Faizabad. He attended the Faizabad Intermediate ACC School and went on to obtain his O-levels and A-levels at perhaps the premier college in the country. That, Mr. President, is, of course, Presentation College, San Fernando. At the University of the West Indies, Mr. Grease pursued a Bachelor of Science in Government with a major in Public Administration, taking up a second-class honors. And he also held a certificate in Project Preparation and Appraisal from the Project Administration Training Unit of the Caribbean Development Bank, and also an executive diploma in public sector management at the UWI Institute of Business. Prior to his appointment to the Senate, Mr. Creese served in a number of capacities in the public service. From 1985 to 1992, he was an investigator at the Office of the Ombudsman. He served in local government as deputy town clerk at the Point Fortin Municipal Corporation from 1992 to 1994, and went on from 1994 to 2008 to be the chief executive officer at several municipal corporations, namely Mearo Rio Claro, Sawa Laventil, and Siparia, eventually being appointed as acting deputy permanent secretary in the Ministry of Local Government. Mr. Creese also acted as the permanent secretary of that ministry in 2011, then reverted to acting deputy permanent secretary from 2011 to 2014, and afterwards he worked as a local government consultant from 2014 to 2015. Mr. Creese also served as the CEO of the National Center for Persons with Disabilities and a director of the Trinidad and Tobago Credit Union Deposit Insurance Fund, and also a director of the Public Service Credit Union Cooperative Society Limited. During his tenure in this Parliament, Mr. Creese served as a member and chairman of the Joint Select Committee on Land and Physical Infrastructure, and that was in 2015. He was also a member of the Statutory Instruments Committee, and he served on various Joint Select Committees that considered many bills, including the Insurance Bill 2016 and the Anti-Terrorism Amendment Bill 2018, to name a few. Mr. President, those who knew Mr. Creese describe him as always courteous, humble, approachable, knowledgeable, articulate, and always willing to help. He leaves behind an undeniable legacy of national service. In conclusion, Mr. President, on behalf of the government bench, we extend deepest condolences to his family. May he rest in peace.
Weber.
Thank you, Mr. President. It is my solemn duty to join in tribute to the late Senator Mr. Stephen Creese. But given his service and contributions to this Parliament and beyond the Parliament to Trinidad and Tobago, I consider it an honor that we have this opportunity to say some positive words and reflections about this servant of Trinidad and Tobago. As has already been shared with the Senate, Mr. Creese was an independent senator of Trinidad and Tobago, having served in that capacity from the year 2015 to the year 2018. He was born on the 6th of February, 1954, and passed from this earthly journey on the 27th of March, 2026. But of course, it's what happened between those dates that we focus on today. Stephen Creese was born and raised in Pepper Village, Faizabad, South Trinidad, to Naomi and Carlton Creese. And he spent most of his life in the south of this country. Being a child of the South, he had an upbringing which focused very much on community and family, with a verdant green surroundings during his childhood and an ethos of service throughout his early years. And that rural upbringing would have helped to shape his life of dedication and service. Stephen Creese was an outstanding student, having attended the Faizabad Intermediate ACC School and a good institution of secondary education, Presentation College, San Fernando, where he obtained both his O-levels and A-levels. So he was a bright student who did well in the formal secondary school system. At the tertiary level, he was also quite outstanding, having completed a Bachelor of Science degree in government with a major in public administration at the UE St. Augustine in 1983, and several other achievements at the tertiary level. So with respect to Stephen Crease's educational background, he certainly had a strong foundation to build on. With respect to his experience and life of service, there's much to be said. He was very much a public servant for most of his career, and one of the early positions in which he served was as an investigator at the Office of the Ombudsman. And from that position, Mr. Crease would have gained a keen appreciation of issues affecting ordinary people in Trinidad and Tobago. He went on to become a deputy town clerk at the Point Fortin Municipal Corporation, went on to become chief executive officer at several municipal corporations over the years, including Mayaro Rio Claro, Sawa Lavantil, and Separia, covering some important parts of the country. And as already been noted, rose also to the highest levels of the public service, acting as Deputy Permanent Secretary and also as Permanent Secretary for several years, before going on to serve as a local government consultant. Some of the most challenging positions in the Republic of Trinidad and Tobago. We also note that former independent Senator Crease served as the Chief Executive Officer of the National Center for Persons with Disabilities. And I would spend a few moments on that particular role. But besides all of this, Mr. President, Stephen Crease was very much a dedicated father to his 3 children and a farmer in his spare time, rearing both fish and fruits. And those endeavors would have bestowed upon him patience, endurance, and a respect for the environment. I said I would spend a few moments on Mr. Crease's time at the NCPD, the National Center for Persons with Disabilities. He served as CEO of that organization from April 2021 to October 2025. And my attention was drawn to a very touching tribute posted by the National Center for Persons with Disabilities upon the death of Senator Crease. I will share a few extracts with the Senate from that tribute, which comes with the voices of those he served very directly. The National Center for Persons with Disabilities pauses to honor and remember the life of Stephen Crease, a man whose connection to the organization spans far beyond his years of leadership as CEO. Though he formally served as CEO from 2021 to 2025, his relationship with the NCPD began many years prior, and he stood alongside the center through its growth and transformation, offering his time, insight, and steady support. He was not just a leader for a period, but a part of the fabric of the organization itself. He believed in the value and potential of every individual. His advocacy for persons with disabilities was not confined to words. It was reflected in his actions and his decisions. in his actions and his decisions. And his continued presence within the organization over the years reflected this. As we reflect on his life, we are reminded that leadership is not only defined by position, but by presence, contribution, and impact. Mr. Crease's contribution to the National Center for Persons with Disabilities, and I dare say, Mr. President, to this Parliament and the Senate as an independent senator, will always be remembered with gratitude and deep respect. His legacy remains part of who we are and what we continue to build. We extend our deepest condolences to his family, loved ones, to all who had the privilege of knowing him and benefiting from his contributions and his life of service. On behalf of this opposition bench in the Senate, we extend our condolences to the family of the late Senator Stephen Crease. May he rest in peace. I thank you.
Senator Dr. Mali-Nats.
Thank you, Mr. President. Mr. President, today I rise on behalf of the independent bench to join the rest of this honorable chamber in paying tribute to a former colleague, Senator Stephen Crease, whose life and service reflected a quiet but steadfast commitment to public duty, to institutional development, and to social inclusion. I do not wish to be repetitive, Mr. President, and has been shared by previous speakers. Mr. Crease served this honorable Senate as an independent senator during the 11th Republican Parliament, and he offered this country 3 years of thoughtful, measured, and principled contributions to the legislative agenda of this country. But, Mr. President, his service to Trinidad and Tobago reached far beyond this chamber. As noted before, Mr. Crease was born and raised in Pepper Village, Faizabad, and his life journey embodied the very essence of public service. A graduate of the University of the West Indies St. Augustine campus, he read for a degree in government with a specialization in public administration. And this academic training brought practical insights to his work. From his early days as an investigator in the Office of the Ombudsman to his leadership across several municipal corporations, including Mayaro, Rio Claro, Sawan Laventil, and Siparia, and ultimately during his tenure in the Ministry of Local Government, he distinguished himself as a public officer of integrity, administrative depth, and practical understanding of how systems must work for people. Mr. Crease understood governance not as something esoteric or abstract, but as service rooted in systems that must deliver for citizens. Mr. President, what perhaps distinguished Mr. Crease most was that he was not only a practitioner of governance, but also a reflective thinker on development. In his contributions to national discourse, he consistently raised issues of fairness, accountability, and institutional coherence. Whether he was questioning inequities in land ownership and advocating that idle or underutilized lands be brought into productive use through taxation, or interrogating the rationale for a separate institutional arrangement, such as a standalone tourism authority for Tobago, Mr. Crease demonstrated a commitment to policy that was both practical and principled. He asked the kind of questions that matter. For example, he would ask, are our policies fair? Are our institutions coherent? Are we using our resources in the best national interest? Mr. President, That same philosophy was evident in his leadership within the cooperative movement. As president of the PSCU Credit Union, he spoke candidly about the need for reform, for resilience, and relevance within the credit union sector. He warned of institutional stagnation, he called for strategic planning and modernization, and advocated for stronger state engagement. He argued that credit unions were not, and according to one of his speeches, they were not poor relations in the financial system, but essential instruments of socioeconomic empowerment that must claim their rightful place in national development. Mr. Creese understood deeply that economic structures must evolve or risk becoming obsolete. Mr. President, as noted earlier, perhaps one of the most defining aspects of Mr. Creese's legacy was his work as the Chief Executive Officer of the National Center for Persons with Disabilities. In that role, among other things, he championed inclusion, dignity, and opportunity, ensuring that persons with disabilities were not treated as an afterthought in development, but as citizens entitled to full participation in society. This was not incidental to his career. It was central to his philosophy. It is therefore no surprise that his contributions in this Senate reflected a sensitivity to social justice, inclusion, and institutional responsibility. As noted earlier by previous speakers, during his tenure in the Senate, Mr. Creese contributed to deliberations on a wide range of critical legislation, from national security to fiscal policy to social development. He also served with distinction as chairman of the Joint Select Committee on Land and Physical Infrastructure and contributed to several other Joint Select Committees, including those examining constitutional reform and national security legislation. He engaged in debates on matters of national concern, including crime, debt limits, and public accountability, always bringing a grounded and thoughtful perspective to the work of this chamber. Mr. President, having consulted with some of his colleagues who worked with Mr. Creese, they recall that he was not a loud or flamboyant presence, but rather steady, thoughtful, and deeply respectful contributor, one who listened carefully, spoke deliberately, and engaged constructively. He represented and embodied the very spirit of the independent bench, measured, non-partisan, and guided always by the national interest. He reminded us, quietly but consistently, that good governance is not boisterous or loud, nor is it about noise, but about clarity of thought, fairness in policy, and integrity of purpose. Beyond public office, he was a father, a man of faith, and someone grounded in community and simple pursuits. And he never lost sight of the lived realities of ordinary citizens and remained a proud son of Faizabad. Mr. President, his passing on March 27, 2026 marks a loss of a public servant, a parliamentarian, and a citizen who gave meaning to the idea of service. On behalf of the independent bench, I extend sincere condolences to Mr. Creese's children, his family, and all those in the disability community, the cooperative movement, and the wider national community who benefited from his work. May his legacy, one of thoughtful service, institutional commitment, and advocacy for fairness and inclusion, continue to guide us. As scripture reminds us in Matthew 25, verse 23, "Well done, good and faithful servant, enter into the joy of your master." May he rest in peace. I thank you, Mr. President.
Honorable Senators, today I join with you in paying tribute not only as President of the Senate, but as one who had the privilege to serve alongside former independent Senator Stephen Creese, whose passing on Friday, the 27th of March, 2026, has caused us all to pause, reflect, and remember a life of quiet but profound service to Trinidad and Tobago. While the funeral service for Mr. Creese is yet to be held on Thursday, the 2nd of April, 2026, I am heartened that other honorable senators have taken the time to speak to his many achievements and contributions. It is most fitting that this august Senate officially place on the record its fervent tributes in recognition of a life that has left an enduring mark in our national tapestry. Senator Creese's journey began in Pepper Village, Faizabad. And from those humble beginnings, he built a distinguished public sector career and pursued a professional life, throughout which Stephen Creese demonstrated a deep understanding of governance, administration, and the responsibility that comes with public office. His career in the public service was extensive and fruitful. From his early days as an investigator at the Office of the Ombudsman, to Deputy Town Clerk at the Point Fortin Borough Corporation, to Chief Executive Officer of several regional corporations, to later serving as Acting Permanent Secretary and Deputy Permanent Secretary at the Ministry of Local Government, Mr. Creese contributed at the highest levels of the public service. However, beyond the title and office he held, some among us will remember Senator Creese and his calm presence, his thoughtful contributions, and his steady approach to governance. When he entered this chamber as an independent senator, he entered as my senatorial colleague in the 11th Parliament, and later served as my chairman on the Joint Select Committee on Land and Physical Infrastructure, where Senator Creese brought with him not only technical knowledge, but practical experience and institutional wisdom. He exemplified the highest ideals of public life: professionalism, integrity, and unwavering moral fiber and standards in his pursuit of national development. I remember appreciatively that Senator Creese led our Committee on Land and Physical Infrastructure as the first to invite and interview both a Prime Minister and a Minister of Works and Transport in a public inquiry that this country's inter-island ferry service. Truly a memorable and pioneering moment in parliamentary oversight. I also remember fondly the Honorable Senator distinctive Nehru jacket which he wore with a certain quiet pride. He followed after maybe my own signature style, of course. But he and I were brothers in fashion of sorts, and believe it reflected his personality, dignified, composed, and quiet, confident. It is often the small human details that remain with us longer after the official records are written. There is a widely quoted saying, and I quote, "Service to humanity is service to God." I believe this saying was reflected in the life of former Senator Creese. His work as CEO of the National Center for Persons with Disabilities in particular showed that his service extended beyond public administration and governance and into advocacy, compassion, and ensuring that persons with disabilities were not forgotten in national development. Transforming his personal experience into purpose, Senator Creese was a powerful and passionate voice for change and a steadfast champion for the dignity, inclusion, and advancement of those too often marginalized. Honorable Senators, in this chamber, we debate laws, policies, and national issues. But today, we are reminded that institutions are ultimately built by people, by men and women who gave their time, their knowledge, and their lives to the service of others. It was Martin Luther King Jr. who once said, "Everybody can be great because anybody can serve. You don't have to have a college degree to serve. You only need a heart full of grace and a soul generated by love. End of quote. Senator Creese was such a man with such a heart and such a soul. On behalf of this honorable Senate and the staff of the Office of the Parliament of the Republic of Trinidad and Tobago, I wish to extend sincere condolences to his children, family, friends, and all who knew and worked with him. He was a faithful man. He was a good man. May his immortal soul rest in perpetual peace and rise in eternal glory. Honorable Senators, I now ask that we stand and observe a minute of silence as a mark of respect. May his soul rest in peace. Thank you, Honorable Senators. The clerk will convey to the family of the late Senator Stephen Creese the sentiments expressed today. Clerk.
Papers.
The Honorable Minister of Planning, Economic Affairs and Development, and Minister in the Ministry of Finance.
Mr. President, I have the honor to lay on the table the following paper as listed on the order paper in the name of the Minister of Finance, the annual audited financial statements of the Development Finance Limited for the year ended December 31st, 2024.
Questions on notice, questions for oral answer.
Hello. Government business?
Mr. President, we are pleased to announce that the government is very happy to answer all 6 questions for oral answers standing on the order paper, and very pleased to report as well that the written answers to questions 60 and 61 have already been circulated to all senators.
Senator Dr. Desirée Marie.
Thank you, Mr. President. Question number 53 to the Minister of the People, Social Development and Family Services, which I think the Parliamentary Secretary will take.
The Honorable Parliamentary Secretary in the Ministry.
Thank you, Mr. President. The Ministry of the People, Social Development and Family Services advises that while there is no standalone protocol specifically governing child separation incidents at major public events, established statutory procedures exist to ensure that children requiring care and protection receive immediate intervention. These procedures involve the Children Authority of Trinidad and Tobago and are implemented in coordination with the Trinidad and Tobago Police Service and other relevant agencies. More specifically, the following may be noted. First, establish protocols for providing immediate and social support services. The Children's Authority, now under the remit of this ministry, is the lead agency responsible for protection of children in Trinidad and Tobago, and as such is responsible for care, protection, and rehabilitation of at-risk children, victims of abuse, or in need of state intervention to ensure their safety and development. The Children's Authority of Trinidad and Tobago does not maintain an event-specific response framework for incidents arising at major events, as its actions are activated upon receipt of a report that a child requires care and protection, pursuant to Section 22 of the Children's Authority Act. This may include circumstances where a child is separated from a parent or guardian, and the parent or guardian cannot be located or identified. At major public events, child separation is usually managed by the Trinidad and Tobago Police Service. If the Children's Authority Contact Center receives a report of a separated child, then an emergency response team conducts an immediate risk assessment and initiates investigation. Information is gathered from the reporter, whether it be the TTPS or the event staff, and if the case has not been reported to the TTPS, Children's Authority ensures that a report is made. The emergency response team, the ERT, assesses the child's immediate well-being through interviews with the child and other relevant parties, and may engage stakeholders such as schools or hospitals. Immediate needs such as food, safety, and medical care are addressed, and psychological first aid may be provided where trauma is identified. The child may also be referred to the appropriate social services for further support. If the child's parents or suitable caregivers cannot be identified, and all efforts to locate them are unsuccessful, the child is deemed to be lacking care and guardianship. In such cases, approval is sought for the child to be placed in the care of the Children's Authority in a designated place of safety, such as a community residence, a reception center, foster care, or another approved facility, following a medical examination. Where a parent or guardian is identified on the same day, the ERT continues its investigation to ensure there are no child protection concerns. This may include community inquiries and a home assessment. If protection or social concerns arise after the child is returned to the parent or guardian, the case is then referred to the case management team for continued case management and monitoring where necessary. Mr. President, I thank you.
Senator Desirée Murray.
Thank you, Mr. President, and thank you, Senator, for that very comprehensive response. Question number 54 to the Minister of People, Social Development and Family Services.
Honourable Parliamentary Secretary.
Mr. President, the Ministry of the People, Social Development and Family Services advises that during Carnival 2026, established child protection mechanisms remained fully operational. These mechanisms were implemented through the ministry's key divisions responsible for child protection and family support, namely the Children's Authority of Trinidad and Tobago, the National Family Services Division, and the Child Affairs Division. As the lead agency responsible for child protection in Trinidad and Tobago, the Children's Authority, over the 2026 Carnival period, operated under its established emergency response and placement framework. While the ministry does not maintain a standalone protocol specifically for incidents occurring at major public events, established statutory procedures exist for responding to situations where a child is identified as being separated from a parent or guardian and requiring care and protection. Full operational readiness and child protection mechanisms remained active throughout the celebrations. The contact center unit operates on a 24-hour basis, with staff rostered across all shifts to receive hotline reports, including reports of lost, separated, or unaccompanied children. Supervisory personnel are assigned on each shift to provide real-time oversight, facilitate decision-making, coordinate emergent cases, and ensure that matters are promptly referred to the appropriate intervention team. The ERT, the Emergency Response Team coordination protocols, remained in effect to enable the prompt dispatch of officers in circumstances where a child is found wandering without a parent or caregiver and requires immediate assessment, protective intervention, temporary placement, or reunification support. Additionally, all Children's Authority intervention units maintain on-call arrangements during public holidays and high-activity periods, including Carnival, to facilitate timely response where field intervention is required. The Authority's Contact Center and Emergency Response Team collaborates closely with the Trinidad and Tobago Police Service in instances where reports of missing or lost children are received, thus ensuring coordinated interagency response, the issuance of necessary police bulletins, and timely recovery and reunification efforts. These collaborative arrangements facilitate coordinated responses in cases involving missing or separated children, including information sharing, emergency response coordination, and protective interventions where required. The second part of the question. During the Carnival 2026 period, Saturday 14th February to Tuesday 17th February 2026, the Ministry, including the Children's Authority, which is under its remit, did not receive or handle any reports involving separated or unaccompanied minors. Notwithstanding the absence of reported cases, all child protection mechanisms remained fully operational throughout the Carnival period to ensure immediate response capacity in the event that such matters arose. Reports concerning separated or unaccompanied minors are typically directed to the Children's Authority of Trinidad and Tobago, which serves as the lead agency for child protection and emergency intervention. The National Family Service Division and the Children's Authority and the Child Affairs Division, are not first responding agencies in matters relating to child care and protection. Part 3 of the question, the Ministry did not conduct any follow-up welfare checks or initiate support, as there were no reported cases involving separated or unaccompanied minors that required intervention by the Ministry or the Children's Authority over the Carnival period. Consequently, no reunification processes were initiated and no post-reunification monitoring activities were required. Thank you.
Just one follow-up question. Parliamentary Secretary, given that the Minister of Homeland Security reported that 6 children were separated from their parents during the Carnival 2026 period, can you explain why none of them were reported as such, or whether there will be any contact with the Trinidad and Tobago Police Service to follow up on those 6 children?
I don't think that arises from the question that is before us. If you have another question, you can proceed.
Thank you. No other questions.
Dr. Desirée.
And finally, question number 55 to the Minister of People, Social Development and Family Services.
The Honorable Parliamentary Secretary in the Ministry.
Thank you, Mr. President. The Ministry of the People, Social Development and Family Services advises that psychosocial and trauma-informed counseling services are available through the Children's Authority of Trinidad and Tobago and partner agencies, that families may access such services through established reporting and referral channels, and that data on the provision and outcomes of such interventions is maintained through the Child Protection Information Management System Plus, CPIMS. More specifically, these services include the following. 1. Psychosocial and trauma-informed counseling services through the Children's Authority as the primary agency responsible for child protection. It acts as the first responder when children are identified as separated or otherwise in distress. In this role, the Children's Authority offers psychosocial and trauma-informed services through direct intervention and coordinated referrals to specialized service providers, ensuring that children affected by separation or adverse incidents receive prompt and suitable support. When a child is identified as experiencing emotional distress, anxiety, or trauma resulting from such incidents, referrals are made to qualified service providers. These may include child protection officers from the Special Victims Unit of the TTPS, internal clinical psychologists of the Children's Authority, the National Family Services Division of the Ministry of the People, Social Development and Family Services, the Division of Community Development and Social Protection in Trinidad and Tobago, and other relevant agencies where appropriate. Services offered may include, but are not limited to, crisis intervention, psychosocial assessments, individual counseling, family counseling, case management, and ongoing monitoring. All interventions follow trauma-informed principles to prioritize the child's safety, emotional well-being, and best interests. The Children's Authority also ensures that both the child and the family can access services provided directly by the Children's Authority and through partner agencies as part of the child's wider support network, thus fostering a coordinated, holistic approach to addressing the needs of the child and the family. When ongoing family support and parenting interventions are necessary, cases may be referred to the National Family Services Division for continued family case management. Pathways by which families can access services through the ministry and through the National Family Services Division. We offer a range of social support services aimed at strengthening family functioning, promoting child well-being, and addressing psychosocial challenges experienced by individuals and families. Families may access these services through walk-in visits to the National Family Services Division district offices, via telephone contact with district offices during normal working hours, and through interagency referrals. These include referrals between the Children's Authority, the TTPS, or other relevant agencies. Psychological first aid, suicide prevention intervention may be accessed through the toll-free hotline 800-2673, 800-COPE. Additionally, families may also access the Children's Authority via its hotline 996 or 800-2014, or by making walk-in reports to any of the Children's Authority's regional offices in Trinidad and Tobago, or through referrals from the TTPS, schools, hospitals, or other partner agencies, and finally, through on-site referrals where the Children's Authority is engaged in public event protection initiatives. Upon receipt of a report, the matter is triaged, assigned for investigation, assessment, and appropriate intervention. Finally, Part 3. The Children's Authority maintains case records and service data through its CPIMS Plus. CPIMS Plus facilitates case tracking, service monitoring, and data-informed planning, while ensuring the confidentiality of information and compliance with applicable child protection legislation and data protection standards. Additionally, this system captures key information relating to the management and monitoring of child protection cases. These include the nature of the report received, the assessments conducted, services provided, including counseling interventions, case status and outcomes, referrals made to internal units. Examples include placement, licensing and monitoring, foster care assessment, and legal services. And partner agencies through the NFS and the Childline for specialized services and reports.
Parliamentary Secretary, the 5-minute period is up for answering. Senator Desirée, any?
Just one follow-up question. Given that it appears that reports need to be made in order to initiate the services, and that these families are usually very vulnerable, especially the children. Is it possible that the ministry can contact children or the families who become separated at public events, given that the families are unlikely to access the pathway that you've just outlined? In other words, is there any relationship between the ministry and the TTPS to identify families and follow up?
Parliamentary Secretary, you can answer.
I believe asked and answered that the TTPS can reach out to the Children's Authority and does.
All right, okay. All right, let's continue, please. Senator Brown, Dr. Amy Brown.
Thank you, Mr. President. On behalf of Senator Melanie Roberts-Rajman, I'm authorized to pose Senate question number 42 to the Minister of 62 to the Minister of Homeland Security. Thank you, Mr. President.
Mr. President, I wish to thank the Honourable Senator for the question. Based on information provided to the Ministry by the Commissioner of Police, the website of the Trinidad and Tobago Police Service experienced a period of unavailability during the month of February and extended into early March 2026. The Commissioner of Police has advised that the interruption arose in circumstances where there was outstanding payments to the external service provider responsible for hosting and maintaining of the website, including an invoice relating to service rendered in 2025 and a subsequent invoice for 2026. Mr. President, I am advised that the matter has since been addressed and the website has now been restored to service. At present, the Trinidad and Tobago Police Service is also undergoing routine maintenance and upgrade activities to improve the functionality and resilience of the platform. As a result, certain features of the website may be temporary or unavailable whilst their technical works are being completed. The Information and Communication Technology Division of the Trinidad and Tobago Police Service continues to implement the necessary technical mitigation measures to ensure the full restoration and ongoing stability of the website in the near future, sir. Thank you, Mr. Speaker.
Senator Amy Brown.
Thank you, Mr. President. I thank the Minister for his response. Mr. President, a supplemental. What measures have been or will be put in place to prevent recurrence of the non-payment issue referred to by the Minister? Thank you.
The Honourable Minister.
Mr. President, the Commissioner of Police, as we are aware, is the accounting officer. So I'll have to get advice from him if I was to answer that question any further.
Supplemental question. The Minister did not see it necessary in the inquiry on the question to inquire of the Commissioner on the issue of a recurrence and prevention of same?
No, I think he has answered. He has said that he will have to get some clarification. Do you have any further supplementary? You're going to 63. Okay, continue.
63 to the Minister of Homeland Security.
Minister of Homeland Security.
Mr. President, Again, I want to thank the Honourable Senator for the question. With respect to part one of the question, based on information provided by the Commissioner of Police, the provisional total number of criminal offences, serious criminal offences, reported across all police divisions between January 2026 from January 2026 is 725. And from February 2026, it is 479. With respect to part two, Mr. President, the provisional total number of serious criminal offences detected across all police divisions for January 2026 is 212, and for February 2026, 85. Mr. President, I wish to note that these figures are provisional as the 2nd of March 2026 and remains the subject of verification and finalization by the Crime and Problem Analysis Branch of the Trinidad and Tobago Police Service, which is responsible for the compilation and validation of national crime statistics. With respect to parts question 3, 4, and 5, crime statistics are ordinarily published by the Trinidad and Tobago Police Service in an official website for public access following its completion of the necessary internal processes, including the compilation, verification, and recording of data into the CAPA database. However, at present, the Trinidad and Tobago Police Service website is undergoing upgrades and maintenance work. As a result, certain features, including the crime statistics portal, are temporarily unavailable. Upon completion of this upgrade, work and finalization, the data validation process, the statistics will be published on the official website of the Trinidad and Tobago Police Service and made accessible to the public in the usual manner. Mr. President, those are the figures and information currently provided by the Trinidad and Tobago Police Service. Thank you.
Mr. President, I thank the Minister for his response. One supplemental, when does the Minister estimate that these upgrades to the website will be completed so that the public would benefit from the information?
Yeah, Minister of Homeland Security.
Mr. President, the police service and the providers are working at this time in order to upgrade the system. As soon as it is completed, sir, all information will be handed over to members of the public. The public will have access to such information, sir. So the time frame might be difficult to say at this time. As soon as completion, all will be well.
Dr. Brown, are you with 64? Next one.
President, we didn't have the summary at the beginning of question time, but with respect to question 64, the request is that a deferral is sought until the return of Senator Robert Rajman.
Thank you. Thank you. That's good.
Public business, government business, bill second reading.
The Minister of Justice.
Thank you very much, Mr. President, for giving me this opportunity this afternoon. Mr. President, I beg to move that a bill entitled An Act to Amend the Probation of Offenders Act, Chapter 13, 15, and for other related matters be now read a second time. In presenting this bill, Mr. President, I propose to commence with certain introductory observations concerning the matter of probation in general. Trinidad and Tobago and countries across the world have gradually reformed their criminal justice systems to improve outdated measures to safeguard the public and maintain law and order. In fact, it is the duty of the state to ensure that those who transgress the law are subject to retributive justice, which is both meaningful and proportionate. The duty, however, should be counterbalanced by the duty to rehabilitate offenders so as to curtail recidivism, and in this context, probation constitutes an indispensable instrument in achieving success in this regard. Probation, Mr. President, is formally recognized by the United Nations Standard Minimum Rules for Non-Custodial Measures, the Tokyo Rules 1988, which were adopted by the 8th United Nations Congress on the Prevention of Crime and Treatment of Offenders in 1990 to promote the use of alternatives to imprisonment. Probation is also highlighted as an important instrument in the treating of children and youth in conflict with the law under the United Nations Convention on the Rights of the Child, 1989, and the United Nations Standard Minimum Rules for the Administration of Juvenile Justice, 1985. In Trinidad and Tobago, Mr. President, the Probation of Offenders Act, Chapter 1351, establishes a legal framework for rehabilitating offenders. However, I ask this Honorable House to note that this act was enacted in 1947, and there have been gradual amendments to the act. However, the act has not undergone substantive or comprehensive reform. Mr. Speaker, the probation office, the probation order is central to the local probation system. It provided offenders with rehabilitative opportunities, thus enabling them to confront the underlying issues of their behavior. It is imposed as an alternative sentence in situations where the gravity of the offense, Mr. President, and the attendant circumstances show that the offender does not pose a threat to the wider community. Probation officers, Mr. President, are social workers to the courts of Trinidad and Tobago, assisting in the rehabilitation of persons who have come before the courts. Mr. Speaker, the probation officers really are the workhorses of the justice system. They operate silently in the background, and most of us are kind of unsure as to what is the extent of the work that they do. Just to give this Honorable House an idea of some of the work that they do, Mr. Speaker. Under several pieces of legislation, for example, the Probation Offenders Act, Young Offenders Detention Act, Community Service Orders Act, Domestic Violence Act, Children's Act, Children's Authority Act, Family Law Guardianship of Minors Domicile Act, Matrimonial Proceedings Act, Family and Children Act, all of these acts, all of these laws, Mr. Speaker, the court that is involved calls upon the probation officer to report to the court on the people or persons who are subject of court orders. There's one problem under the Probation Act, Mr. Speaker. As society and as the justice system has improved and advanced, is that there is no flexibility in the court when dealing with the question of probation. What I mean by that, Mr. Speaker, is you either impose a custodial sentence or you impose a probation order. There's no flexibility for the court to choose an in-between. So, Mr. Speaker, this bill seeks to address that current limitation of the existing framework by introducing what is called split sentencing. This is a hybrid sentencing regime which combines a defined period of incarceration and a subsequent term of supervised probation. The goals, Mr. Speaker, are to strengthen the overall efficiency and effectiveness of the probation as a rehabilitative instrument within the criminal justice system, while ensuring that the wider interests of justice and public protection are served. To strike an appropriate balance between retributive justice, what we mean by retributive justice is custodial sentence, and the need for structured rehabilitative intervention, contributing to measurable reductions in repeat offenders. Promote a more sustainable and humane correctional outcome by reducing the duration of custodial sentence, and provide significant relief to the overburdened and overcrowded prison system. Mr. Speaker, this bill is really one bill, one piece of legislation in a suite of legislation that this government has introduced and proposes to introduce to bring a comprehensive reform to the criminal justice system and to the justice system in particular. We would recall the passage recently of the Civil Division Bill, Mr. Speaker, giving the courts the opportunity to create the small claims division. Mr. Speaker, we have just passed the Law Revision Amendment to bring laws to the people, electronic versions of the law. You can go into your computer and tune into the laws. The Honorable Attorney General has piloted a number of amendments to a number of legislation for the CFATF regime so that we ensure our obedience to international treaties. We are bringing soon, Mr. Speaker, Cabinet has approved the parole bill. The parole bill, Mr. Speaker, seeks, Mr. President, the parole bill. I fall back on my space downstairs. The parole bill, Mr. President, which will give the prison authorities the possibility of releasing prisoners before the time of their determinate sentence. Mr. Speaker, we are bringing amendments to the AJIPA bill, which was brought by my learned friends on the other side, the amendment. We have about 25 amendments coming, Mr. Speaker. We have the Civil Records and Offenders Bill, which will seek to expunge sentences, Mr. President, that are on the record of certain offenders to give persons and offenders a second chance, a clean shot, a second chance. We in this government, Mr. Speaker, recognize that this is a country that we give second chances. We are a compassionate government, Mr. President. Mr. Speaker, we also have what is coming is, Mr. President, the Speaker's Rights Bill soon, which will bring a measure of restorative justice to victims of crime in this country before, during, and after court matters, Mr. Speaker. Of course, we took the very hard approach with the home invasion bill. So, Mr. President, we are balancing the hard approach with also the soft approach. But we are engaging in a comprehensive reform of the criminal justice system. Mr. President, We followed the direction of the Law Reform Commission in 2021 under my learned friend's tenure. The Law Commission produced a research note on the Probation of Offenders Act and set out a number of suggestions for the government to follow. We developed on that, Mr. Speaker, and we sought consultation with the Probation Services Division, Commissioner of Police, the Legal Aid and Advisory Committee, and a number of other stakeholders before coming here today. Mr. Speaker, the bill that is before you today embodies the Commission's recommendations and presents a decisive step towards closing the gaps in our current probation legislation. The purpose of the legislation is clear: to strengthen our system of justice by modernizing the probation framework, enhance enforcement, and expand opportunities for rehabilitation. On the point of rehabilitation, Mr. President, when we came into office, we observed that there was a unit in the Ministry of National Security called the Penal Reform and Transformation Unit. So we were obviously very excited. We said we are going into this unit to assist in the rehabilitation of offenders in the prison. And we began searching. We did not find the unit anywhere. It was there on paper, but where was this unit in actuality? After some research, Mr. President, this unit was created somewhere in 2004 by a cabinet note, number 902. Of course, it went through different ministries: Ministry of National Security, Ministry of Justice 2010 to 15, back to National Security, and now Ministry of Justice. When we actually found it, Mr. President, in 2010, this unit had 10 members, specializing in corrections, law, research, and data. In 2025, when we discovered it, it only had one person, Mr. Speaker, and it was a single research specialist. The decline in the human resources in that department, of course, caused reform and rehabilitation of offenders to take a back seat in the last regime. Of course, the prison authorities conduct their activities and programs with regard to rehabilitation, but nowhere in the central government, Mr. President, did the question of rehabilitation, restorative justice, play any role whatsoever. We intend to change that, Mr. President, and we have now decided to take a decision to revitalize that penal reform unit, to put that on the front burner once more, Mr. Speaker, to ensure justice is served in this country. Mr. Speaker, as indicated earlier, the core change amendment to this Probation Act is to allow split sentencing. The bill also substitutes probation officer with the term of welfare officer, and I'll come to that a little later on. It increases the time which a probation officer may be in effect, probation order may be in effect, from 3 to 5 years. It increases the fines associated with the payment of damages and breach of a probation officer because the fines are inadequate. It provides for additional specific conditions that may be ordered by a court on a probationer, which would assist the court with dealing with possible breaches. So, Mr. President, if we can have a look at the actual bill itself, and we would see that in section 4 of the bill, there are a number of amendments in the definition section. We have introduced the question of dangerous drugs, electronic monitoring device, firearms, non-intimate sample. We have defined probation officer. What was the need for the change in all of this, Mr. President? Is that, for example, if someone is on probation, you can be placed, an electronic monitoring device can be placed on you to ensure that probation conditions are complied with. Those people who are guilty of using dangerous drugs, you can take non-intimate samples under a condition put by the court, so that a probation officer from time to time can ask that person to come in to have a sample taken to see whether there's compliance with the conditions of a probation order. Mr. Speaker, Mr. President, under Section 5, we have introduced the question of the split sentence. The first thing in that section, Mr. President, is that the probation officer can provide or must provide an assessment to the court, which the court will consider on sentencing. The court takes into account certain things, but the introduction of the assessment mechanism would enable a probation officer to obtain a comprehensive and evidence-based understanding of an offender's likelihood of reoffending. This, in turn, would better equip probation officers to recommend conditions of probation that are appropriately tailored to the individual circumstances and rehabilitation needs of each offender. So, Mr. President, you would see under 5 that the court may, in lieu of sentencing him to a term of probation office of imprisonment, make a probation order, or be, in case of offense punishable with imprisonment for 5 or more years, sentence him to imprisonment, and after he has served the term of imprisonment, release him on a probation order on such terms as the court may consider just. So if you have a full term, a custodial term of 6 years, you can serve a 3-year custodial term, come back out into society for another 3 years on a probation order subject to certain conditions. Under 5.4, it spells it out further in detail. For the purpose of subsection 2b, term of imprisonment means in relation to a person serving one sentence, 1/2 of a sentence, or in relation to a person serving 2 or more concurrent sentences, 2/3 of the aggregate of those terms, or 2 or more consecutive sentences, 2/3 of the aggregate of those terms after making such deduction as may be necessary to ensure that no period of time is counted more than once. So, Mr. President, you would see the flexibility that has been afforded under these amendments. I wish to indicate, Mr. President, that this split sentencing option is really a landmark reform. It ensures that offenders are held accountable through imprisonment, but are given a structured support to reintegrate into society. If, however, Mr. President, he fails or he commits another offense, that is the probationer, he will do the full sentence or he will come back to serve the remainder of his sentence. So there's an inbuilt mechanism. We are saying we are giving you a chance, a second chance, come back out into society, do your rehabilitation, and you get a pass to come back out. If not, the court will once more intervene, and then you will have to serve that term inside. Mr. President, Clause 8 of the bill, Clause 6 of the bill, I'll just go back. Clause 6 of the bill introduces and expands the probation term from 3 to 5 years. In its considerations, the Law Reform Commission thought that 3 years may be too small a period to assess the rehabilitation, so you have expanded it to 5 years. So give the possibility of increasing that term of years under which the probationer may be subject to the probation requirements. Clause 8, Mr. President, strengthens Section 7 of the Act by increasing the quantum of damages that may be granted and expanding the conditions that may be attached to a probation order. This approach will ensure that the conditions imposed upon probationers are precise, proportionate, and realistically attainable. It will promote greater equity within the probation process and reduce the likelihood of circumstances in which probationers are inadvertently positioned for failure by imposition of conditions that are unduly burdensome, excessively restrictive, or otherwise unachievable. It will enforce the principle that probation is not a passive measure, but rather an active, structured intervention designed to address the needs of the victim, communities, and offenders in a balanced and effective manner. And that is clear, Mr. President, by we have increased the fines from $150 to $3,000. And furthermore, the conditions under 4 that the court may make a probation order, it can contain provisions against the offender and for the offender that you may participate in community service for a period of time at a specific location. You may wear an electronic monitoring device for a specific period of time. You might have to adhere to a curfew imposed by the court, so that you may not be allowed to go in a geographic area where an offense has been committed, where a victim may reside. You may provide for the purpose of analysis a non-intimate sample prescribed by the court at intervals that are specified by the probation officer, where a provision of the order requires the offender to abstain from the consumption of alcohol or drugs. You're on a drug offense, the court says, I'm letting you out on the condition that you do not participate and imbibe these drugs. The probation officer can call upon him to have a non-intimate sample taken to ensure that the conditions are fulfilled, that you maintain steady employment, that you actively pursue educational, technical, or vocational training as prescribed by the court. Also, that you reside, for example, within a geographic area or facility pursuant to an order of the court. You abstain from communicating directly or indirectly with victim, witness, or other person. You attend specialized rehabilitative programs. You abstain from owning or possessing a firearm and any other conditions as the court may time to time prescribe. Clause 9 of this bill, Mr. President, seeks to confer jurisdiction on the court in two instances. In the first instance, if a probationer breaches the order, the probation officer may make a report, or the court may issue a summons requiring the probationer to come to court to answer questions as to why or if you broke the conditions of the order and whether the court is going to re-sentence you, maybe warn you, but to find out what is going on. So it's an inbuilt mechanism where you have accountability at all stages of the process. Section 10 of the Act of the bill, Mr. Speaker, Mr. President, seeks to amend Section 10 of the Act to build on the jurisdiction to be conferred on the court in Section 9 by allowing written complaints where a probationer has failed to comply with the provisions of the probation officer, and by increasing fines for non-compliance. Together, these provisions enhance enforcement and accountability whilst ensuring that probation orders carry real weight. Section 11, Clause 11, seeks to amend Section 13 of the Act to allow for a variation of the duration of the probation order from 3 to 5 years. This amendment is a result of the proposed increased period of probation. Now, Mr. President, the rehabilitative aspect of this bill is not to be underestimated. In fact, if you are successful in your period of probation, the probationer can apply to the court to have your record sealed. This is a forward-looking measure, Mr. President. It supports reintegration back into society, giving rehabilitated individuals a second chance to build their lives free from the stigma of past mistakes. In other words, you seal, it doesn't show up on your court record. Get back out into the workplace. You can get your certificate of character from the police, which is a requirement these days, it seems, in most places. And you get back on your feet and you move ahead. Right now, Mr. President, to get your record clean, you have to make an application to the Mercy Committee, which takes time. It's a long process. And sometimes from the time of making your application to the time of hearing, I mean, we are dealing with applications right now from 2018, 2019. So you have 6 years, 8 years, somebody commit minor offenses. And for them, they want to get a job, they want to go away, they want to apply for a visa, they want to go to Guyana to work in the oil and gas. This thing comes up on your certificate of character when you go to the police, and you're taking so long. I mean, we're also taking steps to expedite that process in the Mercy Committee. What I'm saying, Mr. President, inbuilt in here, is that once you complete it, you can get your record sealed, and your character is doing it. Now, Mr. President, Those are really the core of the amendments to the bill. I'm trying to foreshadow what might be objections from the other side. They may want to talk about the constitutionality of the bill, Mr. President, and saying, for example, that if a curfew order is ordered or you wear an electronic monitoring device, that somehow that your rights are somehow are going to be affected, and therefore you cannot pass this bill as it is. Has been spoken about many times in this place and in the other place. The due considerations that really have to be applied is coming out of two main cases, Surat and the Attorney General, 2008, and Suraj and the Attorney General in 2022. I didn't realize that spiked a little humor from the others. The important point to note from both cases is that for Parliament initially to strike a balance between the restriction of the fundamental rights and the public interest. Additionally, in determining whether Parliament has struck the right balance, the courts have utilized a proportionality test. In Suraj, the board noted at paragraph 51 that modern conventional approaches to the issue of proportionality involves asking in relation to a measure the following four questions. 1, whether its objective is sufficiently important to justify limitation of a fundamental right. 2, whether it is rationally connected to the objective. 3, whether a less intrusive measure could have been used. And 4, whether having regard to these matters and to the severity of the consequences, a fair balance has been struck between the rights of the individual and the interests of the community. Mr. President, whether the objective of the bill is sufficiently important to justify the limitation of fundamental rights to private life and freedom of the movement must be answered definitively in the affirmative. Reducing duration of custodial sentences serve to alleviate prison overcrowding, whilst simultaneously ensuring that incarceration is reserved for individuals who pose an imminent threat to public safety, demonstrate persistent offending behavior, or have committed serious offenses. Mr. President, on the 5th of December 2020 in the Trinidad Express, it was reported that Trinidad and Tobago had an incarceration rate that is well above the global average. This, however, have had little effect on reducing crime and is really indicative of a highly ineffective prison system. This report was based on the IADB Regional Comparative Report on the Survey of Individuals Deprived of Liberty. In that report, the IADB urged Caribbean governments to actively pursue strategies to reduce the prison population. It recommended alternative methods of punishment to be used for persons who have committed non-serious offenses rather than sending them to prison. Alternative punishment may include community-based sanctions such as suspended sentences, probation, electronic monitoring, house arrest, community service, drug treatment courts and fines, which the IADB said would serve to lower imprisonment rates and reduce the costs of prison system. Mr. President, the IDB report further indicated that prison populations held in overcrowded conditions experience significant deficiencies, including inadequate access to water and food, administrative challenges, and incidents of violence both among inmates and between inmates and staff. The report further noted that these conditions contribute to disturbances, heightened levels of violence, increased rates of repeat offenders. These environments facilitate the spread of infectious disease, including HIV, pneumonia, and tuberculosis. Overcrowding also impedes the effective separation of violent and non-violent offenders, increasing the risk of violent incidents and limiting inmates' access to meaningful rehabilitation and reintegration programs. It is clear that the objective of the bill is sufficiently important to justify limiting some of these fundamental rights, if it is that. Mr. President, I now turn to whether the bill is rationally connected to the objective. It is indeed connected, as it seeks to reduce the overcrowding in prisons by imposing a split sentencing regime. Overcrowded and substantive conditions within correctional facilities constitute a clear breach of fundamental human rights. The two most commonly advanced responses to this challenge are, first, expansion of prison capacity, and secondly, reduction of prison population. The expansion capacity, however, entails significant financial costs, requires substantial capital investment, and has consistently failed to deliver a solution, as new constructed facilities tend to reach capacity within a short period. In 2025 alone, $700 million was allocated to the prison service, according to a Newsday report dated 22 July 2025. By contrast, Mr. President, reducing the prison population through reforms to criminal procedure and sentencing policy represents a more effective, efficient, and enduring approach to addressing overcrowding. I submit that the imposition of a split sentencing regime is rationally connected to the objective of the bill, which aims to reduce overcrowding in the prison system. Mr. President, with respect to the question as to whether a less intrusive measure might have been employed, it must be noted that the existing legislative framework governing the probation system does not expressly provide for clear, specific, and attainable conditions within a probation order. This deficiency has, in practice, resulted in a probation regime that falls short of its rehabilitative objectives. The conditions imposed upon probationers, however, do not exceed prevailing international standards and are consistent with those applied in comparable jurisdictions. The United Nations Handbook on Probation Services states that the courts should take into consideration the rehabilitative needs of the offender, the protection of society, and the interests of the victim, who should be considered whenever appropriate when making a decision on probation. In this regard, the handbook lists a range of non-custodial measures that may include conditional or unconditional discharge, confiscation or an expropriation order, fines, financial compensation or restitution, service, community restitution, psychiatric treatment with or without probation, probation supervision, electronic measuring, measurement, monitoring, etc. Mr. President, the Canadian Criminal Code contains the same provisions that we have put forward in our bill. Also, the recent Sentencing Act 2026 in the UK offers also a useful point of comparison for this House as it seeks to implement the ambitious reform to the criminal justice system by directly confronting the challenge of severe prison overcrowding. And it sets out a whole earned progression model in the UK. Thank you. Mr. President, I now turn to the issue as to whether, having regard to these matters and the severity of the consequences, a fair balance has been struck between the rights of the individual and the interests of the community. There is no doubt that our criminal justice system requires periodic review to address systems failures and to introduce measures for modernity and improvement. Indeed, these policy considerations have come into play as our penal system cannot effectively reduce repeat while our society endures significant and sustained rise in serious criminal activity as experienced over the last decade. Mr. President, all the statistics from the Crime and Problem Analysis Division of the TTPS shows increase in criminal activity. And what is important to note, Mr. President, that the increase in criminal activity coincided with the increase in overcrowding in our nation's prisons. What stands out is that the prison population has more than doubled the capacity of the prisons. Mr. President, this government has brought this bill as part of its legislative package to address the high level of crime. The legitimate aims being sought by the bill are to ensure that the sanctions imposed on offenders are meaningful, proportionate, and tailored to their individual risks and rehabilitative need. In doing so, it aims to reduce the likelihood of repeat offending and to alleviate pressures on the custodial system. Beyond mitigating the strain on an already overcrowded prison environment, the introduction of split sentencing provides an additional safeguard for the public. It ensures that offenders remain under structured, continuous supervision while engaging in rehabilitative interventions. Mr. President, the bill is in accordance with the requirements set out in the recent cases of our apex courts in the cases of Surat and Suraj. The bill is intended to address an issue of ongoing national importance which has arisen over an extended period. Thank you. Previous policy responses, including reliance on the existing legislative framework, has not yielded the desired income. Mr. President, this government bears the solemn responsibility of ensuring that our criminal justice system protects the public, imposes sanctions on those who violate the law in a manner that is both meaningful and proportionate, and provides appropriate support to offenders seeking to desist from criminal behavior. A well-functioning probation service is essential to achieving these objectives. Mr. President, this government remains committed to ensuring offenders are afforded meaningful opportunities for rehabilitation so that they may desist from criminal activity. And this government affirms its conviction that the complex rehabilitative needs of certain offenders are better addressed through shorter custodial sentences coupled with longer periods of supervised engagements within the community. It reflects both modern best practices and our firm commitment to fostering safer, more resilient communities across Trinidad and Tobago. Mr. President, thank you. I beg to move.
Honorable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Probation of Offenders Act, Chapter 13-15, and for other related matters be now read a second time. Honorable Senator Faris.
Thank you, Mr. President. Mr. President, it gives me great pleasure to welcome my friend, the Honorable Minister of Justice, to this Senate, and thank him for the piloting of this debate, of this bill before us, which we're debating. Mr. President, permit me to jump immediately into concerns, recommendations, and discussion about this law. The Honourable Minister has taken us through some of the rationale as to why we need this law. In summary, I've heard so far that there is a need for the balancing of justice between the type of justice which one must give to people who come into conflict with the law, and of course, in the rehabilitative approach that one must take to persons who are in conflict with the law and are in the system, so to say. The Honourable Minister has pointed out prisons conditions, overcrowding. The Honourable Minister has gone through a legislative agenda and has reflected upon a unit in his ministry, which he says revealed to him the fact, according to him, that the central government was not paying attention to rehabilitation, that reform was in the back seat. Permit me to very quickly say that in 2015, when the PNM came into government, the Ministry of Justice and the Ministry of Legal Affairs were absorbed into the Ministry of the Attorney General. Under my command at the Ministry of the Attorney General and Legal Affairs, we created something called a Criminal Justice Unit. The Criminal Justice Unit was that central arm of the government which was charged with dealing with rehabilitation, reform, and prison. One needs only to look at the record of the Parliament and you will see that the amendments to the DNA legislation, the amendments to the electronic monitoring legislation, the creation of the Family and Children Division, the creation of the Children's Court, which deals with criminal matters, the creation of the Criminal Division, the institutional raising of the age of retirement from judges going from 65 to 70, the increase in the number of masters in the Criminal Division from 2 to 25, the suite of legislation incorporated in our near 600 laws, all demonstrate that an active amount of work was there to treat with the criminal justice system and the root causes identified by the minister in this bill. You need only reflect upon the law that we brought to treat with plea bargaining, which was the, if the correct name of the bill is put, it's the Criminal Procedure Plea Discussion and Plea Arrangement Act, Plea Agreement Act 2017. You can look to the Sexual Offences Act, where we treated with incarceration, the bail amendments, all of which are matters which the Honourable Minister focused on in piling this bill. So to say that there was no element of the government charged with responsibilities, unfortunately, representative of perhaps some of these things may have escaped my learned friend in his review of what we were dealing with. Let's get to something that the Honourable Minister flagged, and I'd like to deal with squarely. He said to us that the Cabinet has approved a parole bill. He has said to us, the Honourable Minister, that he's brought forward a 2021 proposal from the Law Revision Committee, Law Reform Committee, to treat with probation. Mr. President, may I say at the outset, I instructed the Law Reform Commission in 2020 to undertake a review of the probation offenders. That was following, in particular, amendments which I piloted in 2016 to this very law to treat with children when we were doing the children's package and children in conflict with the law, which is very much a big part of this bill, which I'll come to in a second. In the period which followed, we spent a significant amount of time accelerating the criminal justice system, dealing with mechanisms by which you can come before the court more quickly, have justice, but have a balancing of rights. Now, the need for amendment to the probation Senator Alahai want to jump up and say, don't come and lecture us and tell us things today and not explain yourself as to why you didn't do it for 10 years. So let me explain that up front. The probation of offenders law was put into second gear because we put into priority the acceleration of the criminal justice system, the creation of divisions of court, etc., rules, procedures, and also because we instructed and I drafted, by instructions to the Law Reform Commission, the parole bill, which I won't go into because it's now before the House of Representatives and I don't want to anticipate that bill. But the parole bill in that House is near carbon copy of one which we left in 2022 when I left it there. Now, why didn't we come forward with the amendments to the probation that the Honourable Minister has brought here today? There was, in fact, a probation package prepared in 2021. The Probation Offenders Amendment Bill 2021 proposed amendments to a few sections, to Section 3 of the Act, which we do today, largely in similar form, and to Section 4. When that came back, we sent it for consultation, and the Probation's Department gave us certain material, which I see present here today. But, Mr. President, in terms of observations today as to the bill as piloted today, the reason for not bringing it forward, I wish to put onto the record because they are the heart and soul of observations about the bill as it is now brought before us. Now, Mr. President, probation on a split sentence system is commendable. I have no issues whatsoever on the constitutionality of this bill. I thank the Honourable Minister for addressing those concerns up front, using the Privy Council's decisions in Suraj and Surat as to proportionality. But I have no concerns there because the Electronic Monitoring Act already provides for electronic monitoring in Section 10 for persons on probation. Because the DNA legislation, the Administration of Justice Deoxyribonucleic Acid Act, also provides for taking of intimate and non-intimate samples for persons in prisons populations. And also because a court order allows for the conditionality of the things which this bill sets out. So taking a non-intimate sample for drug testing, etc., can be viewed to be a condition of your probation. Therefore, it is a consensual transaction between the offender and the state, and therefore that takes away any argument on constitutionality applying in my respectful view. So I wish to assure the Honourable Minister that I have no concerns on that. Probation is necessary in this split system because it's where you're coming to the court for the first time, either in a summary offence occasion, which is Section 3, which we deal with in the bill by way of an amendment proposed in Clause 4, or by way of indictable matters coming before the court. In the current law, the summary route says that the magistrate, now the district officer, of course, the district judge, the magistrate in Section 3 of the Act, and Section 3 of the Act is amended by Clause 4 of the bill. By Clause 5 of the bill. The current law says that if you come before the court with a summary offense, you can either the court may convict the offender and make a probation order, or without proceeding to conviction, make a probation order. Now, the language in Section 3, which Clause 5 deals with, says, where any person is charged before a summary court with an offense which is punishable by such court, and the court thinks that the charge is proved, but is of the opinion, having regard to character, antecedents, home surroundings, health, mental condition of the offender, or nature of the offense, or any extenuating circumstance in which the offense was committed, it is expedient to release. I want to focus there on the wording. It says where you are brought before a summary court. Just to remind the Honourable Minister that with the amendments that we made to the criminal justice system, the Administration of Justice Preliminary Inquiries Act now governs the procedure by which you come before a court, and you may in fact be before a master or before the High Court on a summary charge, and therefore coming before a summary court has a little imprecision to it, which I think needs to be amended. But secondly, this law, this 1943 law, does not take care of the observations which I gave to the Law Reform Commission in 2021, 2022, and otherwise, which is that it does not balance the rights of the victim. Now let's stick a pin. Trinidad and Tobago is under a state of emergency. Trinidad and Tobago has an issue with incarceration, has had for a very long time, on state and conditions. People are going into the prisons. My learned friend was correct in his observations as to the international arena talking about our conditions. Madam Justice Gobin is perhaps the leading judge who has spoken to the condition in our prisons. But my point in saying this is, if you look to the laws which we developed as a parliament under my tenure, you look to Act number 12 of 2017, that is the Plea Discussion and Plea Agreement Act. You will note that there's a Part 3 that deals specifically with victim impact. The requirement that a court, before, in this case, a plea agreement is discussed, or a plea discussion is embarked upon, that the court must engage in a balancing exercise with the rights of the victim. And that is to be found at sections 13, 14, 15, 16, 17, 18 of the plea discussion legislation. Why am I raising it? Because in the law which we seek today to amend in the clauses, we are saying what the court must take into account. We are amending in clause 5, section 3 of the parent law to treat with the summary offences route and the indictable offences route, but we are not including, as I recommend we ought to, the rights of the victim being taken into account in the manner which we now have precedent for. The victim's rights are taken care of in the Family and Children Division package. The victim rights are taken care of in the criminal packages, including plea discussion. Victim rights in a society like this are critical. Stick a pin. Why? Under the Probation of Offenders law, you will note, although there is the impression that this law applies to not so serious matters, the point is the law doesn't prescriptively say so. Section 3 of the Act says summary offences and indictable offences. Mr. President, I thought that my learned friend would come to us, and perhaps he will in his wind-up, with data. I can tell you that as at 2022, the data which I had pulled out of the prison system, coming from the Office of Warrant Clerk, demonstrated that there were in total persons in incarceration, in remand, there were 2,258 persons, men and women, convicted 1,078, giving a total of about 336 people, 3,336 people. And in that, I had asked in my analysis for probation in particular, for a breakdown of persons with offenses 5 years and over, persons who were serving time, persons who were in remand. Mr. President, you will, of course, know, with your long years in this parliament, abduction, armed robbery, attempted murder, breach of Children Act, sex with a minor, breaking and entering with intent, breaking and entering with larceny, buggery, common assault, conspiracy to murder, dwelling house breaking and entering, grievous bodily harm, fraud, grievous sexual assault, harassment, incest, indecent assault, kidnappings, larceny, larceny of motor vehicle, malicious wounding, manslaughter, motor vehicle, murder, possession of dangerous drugs for trafficking, possession of firearms, possession of marijuana, predial larceny, rape, robbery with aggravation, robbery with violence, sex with minor, shooting with intent, trafficking, cocaine, etc. All of these matters had over 5 years incarceration. Now stop for a moment. Go to any one of the summary offenses in the white-collar legislation or the non-blood legislation, the Copyright Act, the Financial Institutions Act, the Insurance Act. Summary offenses are set at $1 million, $2 million. Now I'm drawing that into purpose because in looking at the amendments by Clause 5 to Section 3, you must bear in mind that the law is not prescriptive in treating with certain things. The victim impact is not included. It ought to be included. It is a fundamental requirement before a judicial officer gives you probation, where the law is right now, almost as a matter of compulsion, requires reflection upon the victim. Now, Mr. President, you may say that this law continues to speak. It would be correct. You may say that the court has, in its inherent jurisdiction, in the interest of justice, the rights to do certain things, but it is a matter of course, if we're making prescriptive amendments, that we ought to lay into the law the prescriptions to include the rights and the balancing of rights to improve the constitutionality that my friend is relying with Surat and Suraj to prove. And I think he's right, there's constitutional measure inside of this, but it can and ought to be improved by including those rights. Now, Mr. President, if you go to the rest of the bill, if you go to the definitions section, let's start there. Let's start with clause 4 of the bill. We're including certain provisions. We're including dangerous drugs, electronic monitoring, firearm, non-intimate sample probation officer. But I respectfully believe if you're going to include the issues of the victim, that you ought to include a recommendation for a definition of a relative of a victim. A victim as a definition in and of itself, a victim impact statement. Mr. President, I think that if you're going to include the definition of firearm, you ought to include what we do in law, the definition of ammunition, prohibited weapons, and pepper spray, because that should also be a conditionality that you are not to have possession of those things when we get to the clauses in the bill that propose further conditions. When we get to clause 5 of the bill, currently we leave subsection 1, which treats with the summary route, and we jump to amend the indictable route by introducing the split system. The split system is where you can go to jail and have probation after, or you can not go to jail at all. But Mr. President, if you look to the Parent Act, you would perhaps agree with me that the summary route is inadequate in its language, because we have to do an amendment to the summary court to keep the architecture that we're bringing in now. It really ought to be that where you're charged with a summary offense, not that you're before a summary court. Mr. President, in the amendments that we're making, we do not have in the interest of justice included. It ought to be included. We ought to include specifically in the amendments to the indictable route that we put in the requirement for victim consideration, a victim impact assessment. Mr. President, if we get a little bit lower down to clause 3, you will note that there is a serious complication, and I want to say that my colleague Senator John Bates will deal with this in greater detail, but the statement that we have as to how your sentence is supposed to be considered did come up in the 2021 bill that I saw, but in my own reflections, which I only found because Senator John Bates alerted me to it, I went back and I noted that I had told the Law Reform Commission, you have a problem when you're dealing with the calculation of time, because when you are saying in the calculation of time that 2 or more concurrent sentences, you should have 2/3 of the aggregate of those terms, that means that you can actually be required to serve more time than you were put in there for. If you go to the parole legislation, you go to the Barbados legislation, you go to the Jamaican legislation, if you're looking at concurrent sentences, you go only with the longest period and you go with a period of time. I have no problems with the 2/3 formula. It matches up with the prison's rules, section 283 and 285, where you get a remission of time served, so that if you're put in for a year, you may find that it's only 2/3 of that time. So if you're given 10 years, you may be entitled to remission when 2/3 of that time has passed. But I'll leave that for Senator John Bates to explore a little bit further in her timing and contribution. When we get to the proposals inside of clause 5 further, let's look to the merit to improve proportionality, that a victim impact statement ought to be included, that the judge ought to be given a requirement to traverse that the prosecutor is obliged to inform the relatives or the victim, that a statement is brought forward, a victim impact statement, that the victim impact statement ought to have certain prohibitions as to what it ought not to contain or can contain, that once you meet muster, then it is presented, it is put before the court. I think, Mr. President, it is important because this law treats with children in conflict with the law, and that's another huge reason as to why we didn't bring it forward in the time that I was there, because we were exploring with the Family and Children Division the work which they are doing in treating with children in conflict with the law. Therefore, we ought to be including the victim impact where the victim is a child, how the child is represented, how those particulars are brought forward. Mr. President, when you get to clause 6 and you see the amendments in section 4 proposed, I think it commendable that we're moving from 3 years to 5 years. But, Mr. President, there seems to be an omission on the part of the drafters. Because when you get to section 4, which clause 6 treats with, you're raising it from 3 years to 5 years. But, Mr. President, when you go to subsection 2 of the parent law, you are leaving the residents in an institution being constrained to not past 12 months. So if you're raising the maximum time to 5 years from 3, why are you leaving the resident time, the time where you're put to an institution and you're living there under terms and conditions? How can you leave it at 12 months? If you're raising the upper ceiling for probation, surely you need to raise the upper ceiling for the number of months that you spend there. That repeats itself at clause 11, which proposes amendments to section 13 of the Act. But, Mr. President, it cannot be in a place where we've gone electronic in the court system that we are furnishing 2 orders, as the bill and the Act treats with, one to the probation officer and one to the probationer, and you don't know who is in charge of the probationer. When the probationer comes, they can't find the court order, it may be sealed. Mr. President, this bill is ripe. This Act is ripe. It's one of the amendments I sent to the Law Reform Commission, that they ought to include a register, a national register of probationers, which is a private register, not available to the public, so that the police at any point in time, with the Commissioner of Police in charge of the national probation register, that the Commissioner of Police would know in any district who is on probation or not. Now, that is important because when you come into contact with the law, when you're looking at station bail, when you're looking at bail in the courts and you have to bring a probationer who is outside but who comes into conflict with the law before a court, the 1943 law relies upon an archaic system of communication. If the registrar of the court, if the clerk of the court in the magistracy division and the high court have access to the register maintained by the Commissioner of Police, you're looking at better enforceability, because we need to explain to the people of Trinidad and Tobago, yes, it's all well and good that the government is concerned about, rightfully so, treatment of prisoners, but we cannot have people being afraid of somebody who's going to be out on probation in the same manner that they're afraid of people who are out on bail. Now, Mr. President, that brings me to another point. When you get to this law and you go to the Parent Act says for a probationer who is outside and who comes into conflict with the law, you may find yourself liable for the original crime only if you are convicted. After you are convicted. If this law is to balance the rights of victims, and if bail in our country says if you're charged for certain scheduled offenses, you may have your bail revoked, why are we not amending this law to include the fact that people who are probationers on the outside, pursuant to a court order, they ought to, the minute they are charged for another offense, they have to be brought back before the court. That would give the population some comfort that the rights of the victims are being managed. It would keep you on a... Mr. President, how are you going to wait on a conviction? We have for years been trying to treat with the rapidity of matters coming to the court for conviction. Mr. President, it is impossible to maintain the 1943 architecture that you only lose your probationary status when you are convicted. You ought to be revisited by the court the minute you are charged, and I propose that that ought to be included in this law. Mr. President, the law is not treating with the fact that we have a definition for a child. The parent law in section 19 and elsewhere refers to people who are under the age of 18. That is a child in law. If we're amending this law, we ought to be amending those provisions at the same time. Mr. President, let's look to the restitution that Clause 7 treats with. Clause 7 treats with the removal of the word summary, because they're recognizing that a court treats with things. So Clause 7 amends Section 6 of the Act. And when you go to Section 6, this is revesting of property when a probation order is made. Where a probation order is made by a summary court. But this word summary continues without amendment in the rest of the Parent Act. I think the Honourable Minister should look at that. You can see it in Section 7. Mr. President, let's look at Section 7, which Clause 7 amends. Where the court makes a probation order, that order may contain further provisions that the offender. I respectfully believe that you ought to amend the possession of a firearm to include ammunition, pepper spray, prohibited weapons. I respectfully believe that it ought to be in L, as in Lima, paragraph L. You comply with such other provisions as the court, having regard to the circumstances of the case, considers necessary for securing the good conduct of the offender. It ought to be subject in the interest of justice and the rights of the victim included there. There ought to be a positive obligation on the offender, the probationer, to register by the use of a registry. That ought to be included inside of here as well. Mr. President, when you get to Clause 10, and you are saying that the probation officer is to lay a complaint, perhaps the Honourable Minister will look at the fact that may cause a complaint to be laid. I don't know if social officers in the public employ have the capability to lay complaints with the accuracy required. That's why the register will allow the clerk of the court, the registrar of the court, to cause the complaint to be laid if you use a registration system. But Mr. President, why are we capping a fine to $3,000? We're going to $5,000. Look at Clause 10. We're saying in Clause 10, which amends Section 10 of the Act, that we will raise the fine. I know the gut instinct is to try and adjust it, but Mr. President, you really have to look at the court itself. Look at Section 10, subsection 4 of the Parent Act. Where it is proved to the satisfaction of the court by which a probation officer was made that a probationer has failed to comply with any of the provisions orders, then the court may impose on the probationer a fine not exceeding $5,000. Mr. President, a breach of the public health regulations was $250,000 because it's the upper ceiling limit. You may get a reprimand and discharge. You may get on a sliding scale. But to put $5,000 and to leave it the way it was, $300, obviously I commend the Minister for bringing this forward. My recommendation to the Law Reform Commission when I was looking at this was put it without a limit, or a limit which was at least in keeping with the Interpretation Act, because the Interpretation Act limit is much higher than that. It should be at least $250,000. Mr. President, I heard a behind me. That's because the sliding scale allows for an imposition of absolutely no charge at all, but it gives that upper limit. Why? Because summary offenses that are white-collar in nature, victims being in financial crimes, bloodless victims, they may be ripe for the type of probation, but why should they escape with a fine of $5,000? You see, because Section 3 of the Act does not disaggregate between simple and complex summary offenses or indictable offenses, we cannot assume that $5,000 is an adequate remedy because the means of the offender may be much greater in a bloodless crime. And that's why I make the submission. Mr. President, when we go to Clause 12. Section 12 of the Act, Mr. President. Section 12 of the Parent Act. I would invite the Honourable Minister to look at the effect of the Administration of Justice Preliminary Inquiries Act, because this is the port of access when you're caught. A JIPA sets up a formula which is different to the formula being used in Section 12 of the Parent Act, and I think that that requires consideration. When we go to Section 13 of the Act, which this bill proposes to amend as well, by raising the period to 5 years from 3 years, again, the 12-month period limitation on occupation at a residence comes into stark focus. It ought to be raised perhaps to 24 months. I don't know what the policy is behind that. Mr. President, when you get to Section 14 of the Act, Section 13 of the Act, surely this is the time where we can allow a court ex proprio motu of its own volition to cause an amendment or variation to an order. It ought not to be confined to the probationer or the prosecution. A court ought, in the interest of justice, in the exercise of its inherent jurisdiction, to have the liberty to look at those things, Mr. President. Mr. President, let's go to Section 15 of the Act, which is proposed to be amended by the sealing of records. I support this. But what we do with the sealing of records is we usually tie it on to an ability to expunge the record expressly stated. And if you go to the Dangerous Drugs Act, the amendments we made to the cannabis management, you will see that we amended, if I recall it, Section 50, I can't remember the section offhand, of the Police Service Act, to allow for an application to expunge. Now, Mr. President, the Honourable Minister mentioned the operation of the Mercy Committee, because that's a part of how you treat with your record. The Mercy Committee was complicated in years of trouble by a decision in the Privy Council known as Lendor. Lendor requires every individual matter to be heard by the Mercy Committee. Really and truly, this is a commendable amendment to Section 15 of the Act, where we're potentially having the order sealed. But really, if we want to get to a further step, knowing how complicated it is, a direction from the court not only that the matter be sealed, but that it be expunged may be in order, in the interest of justice. So, Mr. President, I believe I end in 5 minutes, do I? 4-6. So, Mr. President, the Probation of Offenders law is a 1943 law. It was amended in 2016, where we introduced the Children's Amendments for child offenders. After 2016, Family and Children Division, Criminal Division, the Criminal Proceedings Rules, the divisions of court wider, the expansion of the judiciary, increase in judicial age of retirement, the AJIPA to abolish preliminary inquiries, plea bargaining, maximum sentence indications, all Public Defenders Division, all of these things came about. The Probation of Offenders law is necessary because it allows you at the moment of coming to the court to be treated with the option for probation. I support the split sentencing where you can serve time and then be directed to have probation after. But it is inextricably connected to the amendments in parole, which is the Administration of Justice parole amendments that I had drafted back in 2022 and which I believe is in exact form in the House of Representatives now. There are two different systems. One is early release while you're inside of there to better organize Section 243 and 245 of the prison's rules to make it in prescriptive law. But this law, coming to speed now, has to factor the abolition of preliminary inquiries and the introduction of a JIPA. It must factor the fact that we have children now under the age of 18. We have to most respectfully consider victims before you talk about probation. Victim impact statements. We ought to consider in the administration of justice the introduction of a register, a national register of probationers, so that there is easy access to the courts and to the police, so that people know the police know that there's an offender somebody who's on probation living next to you. After all, we created the Sex Offenders Registry, which was part private, part public, where we created a web version of it after certain conditions were met. It ought to be that we move away from your denial and removal of the benefits of being a probationer. We need to remove away from that happening only on conviction by bringing you back before the court the minute you're charged. And therefore, the apparent law needs to be amended to include that. We ought to introduce in the powers of the court the requirements, the positive requirements on the offender, the probationer, to have registration satisfaction. Mr. President, if you're going to take the step to seal the record, let's go the full distance. Let's seek the expunging under the Police Service Law, the Police Service Act, a direction of the court. Mr. President, the issue of children in conflict with the law. I mean, my learned friend, when he said that nothing was happening in the last government in terms of central focus, and then read the United Nations recommendations, where he said that Caribbean countries should consider drug enforcement, drug treatment courts, etc. We have a drug treatment court. It's up and in operation for children. We have applied the anonymization of children in those courts. If you want to take the children's package properly into this law, you need to include the anonymization of children's records. I noticed something that caused me great concern recently. Children under preventative detention orders, their names and faces were in the public in the press. I have to look to see if that's in contradiction with the law, in contravention with the law. Children, if you want to take them out of conflict with the law, have to be given a different treatment. This law has issues that can treat with that. It's why we did not bring the amendments to the probation law without bringing the parole amendments first. I was quite surprised to learn that we were in the Senate with this law and in the House with the other law, because they are rationally connected. At my point in time,
President, we're going into the realm of tedious repetition. I've been very patient.
I think you should.
I'm wrapping up. My Lord, what a deal. Thank you, Senator. Mr. President, when you're trying to make a serious point, I think it's important to catch the heads that you want to get onto, and for the record to repeat them into summary form and fashion. So in moving to a conclusion on a very serious matter, I welcome the learned Minister of Justice in his presentation of this bill. I respectfully believe that there's more work to be done on the bill. I don't put it down in any pejorative fashion to the minister's ability or intent, etc. I know him as an honorable man, and therefore I am sure that he has come here with honorable purposes. With that said, these are very serious issues that I'm raising. Mr. President, I propose to put some recommendations for consideration by my learned friend at the committee stage, and I thank you for the opportunity to contribute.
Senator Vieira, SC.
Thank you, Mr. President. I rise to indicate my wholehearted support for this bill. This is a thoughtful and important reform to an area of criminal justice that is sometimes overlooked, but which plays a critical role in a modern and humane justice system. So I wish to commend government for its proactive efforts in this regard. Now, with a view to putting probation in context, it may be helpful to share some general reflections on crime. Our national conversation about crime is often reactive. But if we truly wish to shape safer communities, we must be proactive. We must begin with the end in mind, not merely having fewer crimes, but stronger institutions, restored communities, and a just society. Crime is not a disease with a single cause or cure. It is a symptom of social breakdown. And the truth is, we can't legislate our way out of crime. Legislative tools, while necessary, must be matched by strategy, vision, and coordination. One might characterize the scourge of crime in modern society as a multi-dimensional crisis that reflects and exacerbates underlying social, economic, institutional, and moral failures. It is not merely a breakdown of law and order, but a system of deeper systemic dysfunctions, including persistent inequality, social exclusion, under-resourced justice systems, and the erosion of public trust in our institutions. Indeed, one can say that the scourge of crime today is not merely a policing or legislative problem, but a societal challenge that requires an integrated whole of government, whole of society response grounded in justice, opportunity, equity, and accountability. Addressing crime calls for preventative strategies, not just punitive ones. It demands a reimagining of public safety as a shared civic and institutional duty, not just the burden of the criminal justice system. And if we only respond with episodic crackdowns, military deployment, and civilian policy, and hard power, we will remain trapped in cycles of violence. The crime crisis has been years in the making, and it will not be easy to walk back. If we hope to effectively tackle crime, we must identify and tackle the underlying problems. We have to rethink not just what we are doing, but the ways we are doing. We have to move beyond this false dichotomy of prevention versus enforcement. The answer is not either or. The answer is both and more. Modern evidence shows that durable crime reduction requires combining precision enforcement, justice system reform, prevention, and early intervention, community legitimacy, trust building, and institutional modernization. Certainly there's a place for hard power, but there is also a place for soft power, where the focus is on using restorative justice mechanisms for applicable offenses, early intervention, education, reform, and restoring public trust. At its core, this bill recognizes a principle that criminologists, courts, and policymakers have long understood, that punishment alone does not always produce justice, and incarceration alone does not necessarily produce rehabilitation. A justice system worthy of its name must protect society and hold offenders accountable, and at the same time seek to restore individuals so that they may return as productive members of the community. Probation is one of the mechanisms by which that balance is restored. Today is the 1st of April, but this is no jokey legislation. Probation must be taken seriously because it is a court-ordered sentence. It's not a get-out-of-jail-free card. It's a court-ordered sentence that functions as a direct alternative to incarceration. And failing to comply with probation conditions, such as missing meetings, failing drug tests, or failing to pay the fines, can result in serious consequences, including revocation of the probation and immediate imprisonment for the remainder of the original sentence. Probationers will be under active supervision and monitoring. They may be subjected to random searches of their person or property, drug testing, and electronic monitoring. In short, not treating probation seriously can result in a complete return to prison, making it crucial for the probationer to understand all the rules, to maintain communication with the probation office, and to treat the conditions or the requirements as a top priority. In summary, this bill proposes several amendments to the Probation of Offenders Act, which we have heard has been around for a long time. It's designed to modernize the framework governing probation orders. The bill introduces several notable changes. First, it expands the sentencing options available to the courts. In certain circumstances, where an offense carries a penalty of imprisonment of 5 years or more, the court may impose imprisonment and thereafter, having regard to the offender's character, antecedents, home surroundings, health or mental condition, the nature of the offense, or to any extenuating circumstances, release the offender on probation on such terms and conditions as the court considers just. As the Honorable Minister has rightly pointed out, where it's no longer an either-or situation with imprisonment or probation, the bill allows for split sentencing. Secondly, the bill provides that an assessment by a probation officer may be considered by the court before making a probation order. This recognizes the importance of informed sentencing. Courts benefit greatly from professional insight into an offender's behavior, character, background, and circumstances. Thirdly, the bill extends the maximum duration of probation from 3 years to 5 years. This gives the court greater flexibility to supervise offenders over a meaningful period. Fourthly, the bill modernizes the conditions that may be attached to probation orders, and these include participation in community service, wearing an electronic monitoring device, curfew requirements, abstaining from drugs or alcohol, participation in rehabilitation programs, maintaining employment, undertaking education or vocational training, and complying with other conditions designed to secure good conduct. Fifthly, the bill strengthens the enforcement mechanisms by allowing probation officers to bring breaches before the court by laying a complaint in writing. Finally, the bill introduces a new provision allowing a probationer who successfully completes probation to apply to have the record sealed, subject to the satisfaction of both the probation officer and the court. Taken together, these reforms reflect a clear policy direction, a modern probation regime centered on accountability, supervision, and rehabilitation. Mr. President, at its heart, the law is about humanity. Probation occupies a distinctive and valuable place within the criminal justice system throughout the Commonwealth because probation offers a hand instead of a hammer. Traditionally, sentencing has involved imprisonment, fines, or other punitive sanctions. Yet over time, courts and legislatures recognize that not every offense and not every offender requires incarceration. Probation developed as a structured alternative to imprisonment. Under probation, an offender remains within the community, but is subject to supervision by probation officers and to conditions imposed by the court. The offender remains accountable to the justice system, but the sanction is directed towards reform rather than mere punishment. And this approach recognizes an important truth. Prisons serve necessary purposes in the incapacitation of dangerous offenders, deterrence, and punishment. But prisons also carry risk. Criminologists have long warned that prisons can sometimes become environments in which offenders learn further criminal behavior. They form criminal associations, and they become entrenched in cycles of offending. Prisons are places where the wicked gather. They are the universities of crime. And for certain offenders, particularly first-time offenders, young offenders, or those whose crimes arise from circumstances such as addiction, unemployment, or social disadvantage, structured supervision in the community may be more effective than incarceration. Probation recognizes that criminal behavior often has underlying causes, and those causes may include substance abuse, lack of education or employment skills, unstable family environments, mental health issues, or social marginalization. Simply placing an individual in prison does not necessarily address those underlying drivers of behavior. Probation, by contrast, allows the courts to require offenders to participate in treatment, counseling, training, or structured programs designed to address the causes of offending. So in that sense, probation reflects a broader philosophy increasingly recognized in modern criminal justice systems: rehabilitation and restorative justice. Criminal justice must always protect society and uphold the rule of law, but justice must also seek to restore and rehabilitate individuals wherever possible. The principle of rehabilitation has long been recognized in sentencing jurisprudence throughout Commonwealth jurisdictions. Courts routinely acknowledge that the aims of sentencing include not only punishment and deterrence, but also rehabilitation and reintegration into society. Probation serves this objective directly. It allows the court to impose conditions that encourage lawful behavior and constructive engagement with society. For example, the bill allows probation orders to require participation in rehabilitation programs, educational or vocational training, maintenance of employment, and abstinence from drugs or alcohol. And these conditions are not merely symbolic. They aim to change behavior, to equip individuals with skills, and to create pathways back into lawful community life. In many cases, the most effective way to prevent crime is not simply to punish the offender, but to remove the conditions that led to the offense in the first place. I think the Honorable Minister said that Trinidad and Tobago has, on the global scale, one of the largest incarceration rates, and yet it's done very little to reduce crime. This legislation will move away from the traditional approach where we treat those who may have erred as deserving of punishment only, rather than as possibilities to be cultivated. One of the most damaging consequences is the disruption of family life. And to a significant extent, the poor are victims of a flawed economic and social order. The traditional legal system will often compound this because sending an offender to prison will often financially ruin an already poor family. When individuals are imprisoned, families often suffer profound consequences. Loss of income, emotional trauma, breakdown of parental relationships, long-term social dislocation. Children in particular are affected when a parent is removed from the household. They become forlorn, forsaken. Probation allows offenders to remain in their communities, maintain employment, and support their families while still being held accountable. And this helps preserve family stability, which is itself one of the strongest protective factors against future offending. So in that sense, probation is not merely about the offender, it is about the wider social fabric. There's an additional dimension to this legislation, and the Honorable Minister touched on it. Maintaining prison facilities and incarcerating offenders is expensive for the state. Prisons require infrastructure, security personnel, healthcare services, ongoing operational costs. Probation, by contrast, is generally less resource intensive while still providing structured supervision and accountability. When an offender remains in the community, that person can continue to work. He can continue to contribute economically. He can continue to pay taxes. Thus, probation can represent not only a humane alternative, but also a prudent use of public resources. Probation can help reduce prison overcrowding. When prisons are overcrowded, several consequences follow. Pressure on prison administration, strain on rehabilitation programs, increased tensions within the facilities, and diminished opportunities for effective reform. Probation helps alleviate that pressure by ensuring that only those offenders who truly require incarceration are sent to prison. And those who can safely be supervised within the community are managed in a way that promotes rehabilitation while preserving prison space for serious offenders. Another strength of probation is that it allows our courts to craft tailored responses to criminal behavior. Under the amendments before us, probation orders may include measures such as community service, restitution to victims, curfews, electronic monitoring, and participation in rehabilitation programs. And these tools allow the court to impose structured accountability that reflects the specific circumstances of each case. So, for example, a person whose offending is linked to addiction may be required to attend treatment. A person lacking skills may be directed towards vocational training. A person whose conduct has harmed a victim may be required to make restitution. In other words, these amendments will allow our courts to design orders that reinforce positive norms. And they will certainly have a greater effect in terms of reducing crime and certainly recidivism. Now, let me say something about community service orders. I once did a plea bargain, and I got my client a community service order. He had been charged with a drug offense. The community service order was he was a carpenter by trade. He painted an orphanage and did restorative work. And he faithfully carried out his community service order. It reported back to the court, and the case, he did his thing, and he cleared his name. And I want to tell you that was one of my most satisfying moments in the criminal justice system, to see how a person, given a second chance, could take that second chance and turn his life around. He never fell into trouble with the law again. So community service of orders can offer numerous benefits to both the community and to the individual performing that service. Community service orders can provide valuable unpaid work that address specific needs, improve public spaces, and offer alternative sentencing options that reduce reliance on incarceration. They offer the offender a chance to make amends, to develop new skills, to gain a sense of responsibility. They give offenders a chance to clear their debt to the community. Similarly, restitution orders are a form of restorative justice which seek to heal rather than punish. Because here, the offender, the victim, and others who are affected can come together and to discuss what happened, the impact, what can be done to repair the harm. Here, the offender will take responsibility by trying to repair the damage or by satisfying the needs of the victim. As regards the use of electronic monitoring, learned experience abroad shows that this is one of the best methods for improving prevention and ensuring the safety of victims, especially in domestic violence cases. Because these electronic monitoring bracelets provide tracking information in real time regarding the offender's location using a GPS tracking device. And the victim can carry a warning device. So the device not only tracks the GPS location of the offender, but it can send alerts to the victim and law enforcement if a particular geographic location or a defined exclusion zone is breached. So it can therefore act as a warning signal to the one that wears it and to potential victims. Mr. President, all in all, this legislation offers justice that is responsive, proportionate, and constructive. Justice that can and should discourage those who have erred from going deeper down the rabbit hole of crime. This bill recognizes the role of probation officers and the probation system by modernizing terminology and strengthening the ability of probation officers to supervise probationers and to bring breaches before the court. Probation officers serve as a critical bridge between the court, the offender, and the community. They monitor compliance, they provide guidance, and ensure that the offender remains accountable. As the minister said, their work is often quiet and unseen, yet they are essential to the effective functioning of our criminal justice system. I turn to the record sealing and the reintegration, because I think that is one of the most forward-looking aspects of the bill. The provision allowing a probationer who successfully completes probation to apply to have the record sealed. And this reflects an important principle. If an individual has complied with the law, completed with the conditions imposed by the court, and demonstrated rehabilitation, then society should allow that person the opportunity to move forward without lifelong stigma. When I used to practice at the criminal bar, I used to get, I tell you, letters and letters of people just begging for employment. They would take anything, working on an estate. Nobody would touch them because they have a prison record. They had a charge. And so in a way, we almost force them back into a life of crime. You know, this is important because this is a way to break that cycle. The sealing of records, subject to judicial oversight, supports reintegration and reduces barriers to employment and social participation. It offers hope to those who are willing to repay their debt to society. Not vainglorious hope, but hope which is cultivated and fostered. The courts pursue the competing goals of substantial justice, procedural fair play, and efficiency. Probation represents a justice philosophy that is both firm and constructive. On the one hand, it holds offenders accountable and protects the public. But on the other hand, probation also recognizes that the ultimate goal of criminal justice is not just punishment, but working towards the creation of a safer and more stable society. By strengthening the probation system, this bill advances that goal. It promotes rehabilitation over mere retribution. It reduces the social disruption caused by incarceration. It allows offenders to maintain employment and family ties. It provides courts with flexible tools to address the root causes of criminal behavior. Let me conclude with this. Tackling crime requires four things: vision, analysis, people, and execution. But above all, it requires coherence. We are in a war, whether we realize it or not. Our law enforcement and protective services must be able to respond to events and to read the mood. We need a holistic approach that puts together policy, strategy, and plans. We need a mixture of hard and soft tactics. And we need a system that is in harmony with the needs and values of our society. This legislation reflects a modern understanding that justice must be both effective and humane. This legislation, I think, is a step in that direction. And as such, I'm pleased to support it. These important amendments go beyond just inflicting punishment on wrongdoers. The restorative justice, the reparative justice aspects may also have the profound effect of healing wounds, restoring dignity, and laying the foundation for a better country. I thank you.
It's a good time for us to suspend, to have some tea, and when we return, I'll recognize Senator Desirée Marie as the next speaker on the independent bench. And then I go to the government. I put the Attorney General on notice. I'm coming to him afterwards. This sitting is now suspended until 5:20 p.m. This sitting is now suspended until 5:20 p.m. Okay.
Senator Desirée Murray.
Okay, thank you, Madam Vice President, for recognizing me. I wish to lend my full support to the Probation of Offenders Amendment Bill 2026. But before I proceed, I wish to pause and acknowledge the remarkable convergence of observances that frames this moment in our parliamentary calendar. We debate this bill during a period of profound spiritual significance for the people of Trinidad and Tobago, a nation shaped by the confluence of many faiths, many traditions, and many struggles for dignity. Recently, our Muslim brothers and sisters observed the sacred month of Ramadan, a season of fasting, prayer, and reflection, and celebrated Eid al-Fitr, a festival that proclaims joy, renewal, and gratitude after a period of discipline and devotion. On the 30th of March, we marked Spiritual Baptist Liberation Day. The story of the Spiritual Baptists, also known as the Shouter Baptists, is a story of resilience. The story of a people who were once cast outside the protection of the law and who overcame injustice. The story of a people who forgave their transgressors and who, through the long arc of history, found liberation. We stand also in the middle of Holy Week and on the threshold of the Easter weekend, the central observance of the Christian faith. Christians hold that Christ, in dying, absorbed the weight of human transgression, that in his crucifixion lay the possibility of forgiveness, and in his resurrection, the promise of new life. Easter, at its core, is a declaration that no person is beyond the reach of redemption, no matter how far they may have fallen. In Romans chapter 5, verse 20, the Apostle Paul wrote, "Moreover, the law entered that the offense might abound. But where sin abounded, grace did much more abound." It is therefore not coincidence, it is providence, I think, that we should be called to debate a bill concerning the rehabilitation of offenders at precisely this moment, a time that calls us from three distinct but spiritually resonant traditions to reflect on renewal, on resilience, on the possibility of transformation, and on our collective capacity for forgiveness of those who have transgressed. The Probation of Offenders Amendment Bill 2026 calls upon us to acknowledge that a person who has broken the law is not permanently defined by that act, but rather that there is a possibility of new life, second chances, and restoration. This bill presents a significant and long overdue opportunity to strengthen one of our most critical but chronically under-resourced pillars of the justice system, the Probation Service of Trinidad and Tobago. Madam Vice President, I was moved to speak today because this bill is not merely a technical amendment to Chapter 1351 of our laws. This bill speaks to our values as a society, how we treat those who have transgressed, how we protect our communities, and how seriously we take the goal of rehabilitation over punishment for punishment's sake. Probation allows offenders to be reunited with their children, their parents, and their siblings sooner than a custodial sentence would. It is a fact that probation increases the likelihood of rehabilitation and reintegration. This is especially important for women and girls. Women who enter the criminal justice system are frequently the casualties of intersectionality. They are often the victims of violence, addiction, poverty, and abuse. A probation order with appropriate conditions and support is far more likely to produce lasting change in the life of a female offender than a custodial sentence that separates her from her children and removes whatever stability she may have. This is particularly relevant in a country where the social consequences of maternal incarceration fall disproportionately on children and families. So this bill comes not a moment too soon, and I applaud the Minister of Justice and, by the extension, the government for bringing these amendments. My contribution today will be divided into 5 parts. First, the global evidence base on probation and reoffending. Second, the statistical realities of crime detection in Trinidad and Tobago compared to the United States and the United Kingdom. Third, the current state of our probation service. Fourth, the bill's provisions. And fifth, the implementation concerns that must be addressed if this legislation is to achieve its intended purpose. It is instructive to consider the body of international research that underpins the philosophy of probation as an alternative to or complement to custodial sentences. The evidence is compelling and consistent. A landmark study by Muse et al. In 2015, commissioned by the UK Ministry of Justice, found that custodial sentences of under 12 months without supervision on release are associated with higher levels of reoffending than sentences served in the community through court orders, specifically community orders and suspended sentences. This is not a marginal finding. It is a statistically significant result that should inform how we sentence offenders in Trinidad and Tobago. A 2015 systematic review by Velitas, Galerian, and Kilias, published in the Journal of Criminology, compared 4-year recidivism rates for prisoners versus probationers across multiple categories of offenders. Their findings were striking. In every single category, probationers reoffend at significantly lower rates than those sentenced to prison. Moreover, offenders sentenced to prison reoffend more quickly than offenders placed on probation. So the case is clear. Community-based supervision, when properly resourced and administered, produces better outcomes for individuals and for society. Trinidad and Tobago is not alone in recognizing the need to modernize its approach to the management of offenders. In 2014, the United Kingdom enacted the Offender Rehabilitation Act, the centerpiece of its transforming rehabilitation program. Prior to this act, adults serving custodial sentences of less than 12 months were released unconditionally after serving half their sentence, with no supervision or support whatsoever. The Offender Rehabilitation Act introduced a new period of post-sentence supervision for all offenders sentenced to less than 2 years in custody, extending statutory rehabilitation to an additional 45,000 offenders per year. This is precisely the philosophy embedded in the bill before us today, that a period of imprisonment followed by a structured period of probation is more likely to result in genuine rehabilitation than either a bare custodial sentence or an unsupported release into the community. A 2019 analysis by the UK Ministry of Justice analytical series found that short-term custody combined with supervision on release was associated with statistically significant reduction in proven reoffending compared to unsupervised short-term custody. The UK's experience validates this approach that the bill before us now proposes for Trinidad and Tobago. But to understand the true value of probation in the context of our criminal justice system, we must first confront an uncomfortable statistical reality: the gap that exists between crimes committed, crimes recorded, and crimes solved. According to figures provided by the Crime and Problem Analysis Branch of the Trinidad and Tobago Police Service, the current crime detection rate in Trinidad and Tobago stands at 29% for January 2026 and 18% for February 2026. This is hot off the press and was confirmed by the Honorable Minister of Homeland Security, Roger Alexander, in his response to a question posed by opposition Senator and leader of opposition business, Senator Dr. Amory Brown, this afternoon. According to Minister Alexander, for January 2026, 725 crimes were reported and 212 detected. And for February 2026, 479 crimes were reported and 85 detected. What this means is that as much as 82% of crimes committed in this country go unsolved. This has profound implications for our ability to accurately measure recidivism. If offenses are not detected, prosecuted, and proven, they cannot be counted. Our 18% detection rate in February 2026 means that we are measuring only a fraction of the true reoffending picture. For context, I note that the United Kingdom faces a similar challenge. So this is not unique to Trinidad and Tobago. The crime survey for England and Wales estimated 8.4 million crimes took place in the year ending December 2023, while the police recorded only 6.7 million offenses. This represents a gap of approximately 20% between crimes committed and crimes recorded. And this is before we even consider detection rates. The UK Home Office's official statistics for the year ending March 2024 reveal that only 5.5% of victim-based offenses, such as assault, robbery, theft, murder, resulted in a charge or summons, compared to around 11% of non-victim-based offenses, such as shoplifting or handling stolen goods, a difference of 5 percentage points. In terms of investigation timelines, victim-based offenses in England and Wales took an average of 40 days from recording to charge or summons. And furthermore, the most common outcome of victim-based offenses was, quote unquote, no suspect being identified, which accounted for 43.1% of closed cases. So these statistics underline and underscore the importance of disaggregated data as it provides a more realistic and helpful analysis of crime statistics. In the United States, the Federal Bureau of Investigation's 2024 Reported Crimes in the Nation report, released in summer 2025, and covering crime reported between January 1st and December 31st, 2024, also provides a useful comparative benchmark. Based on data from the Uniform Crime Reporting Program through the National Incident-Based Reporting System, the U.S. murder clearance rate was 61.4% in 2024. By comparison, Trinidad and Tobago's overall detection rate of 33% across all crime categories is deeply troubling and underscores the urgent need for every available tool, including probation, to reduce recidivism among those who do enter the system. Madam Vice President, the Probation Service of Trinidad and Tobago was established in 1947 under the Probation of Offenders Act, Chapter 1351. It is noteworthy that clauses 14 and 15 of the bill would provide for the Act to be amended throughout by deleting the words welfare officer probation wherever they occur in the Act or any written law, and substituting the words probation officer. The recognition in law of probation officer as a profession is long overdue and will strengthen the profession. It is important that this Senate understands the full scope of what a probation officer in Trinidad and Tobago is required to do, because it extends far beyond supervision of offenders. These are listed in the Parent Act in the Probation of Offenders rules under the heading of duties and include preliminary inquiries, as the court may direct, visits to the probationer, visits to the school for children attending school, observing conditions and laying reports of breach, advising and assisting the probationer, not wearing a uniform or badge that is distinctive of his office, and being conversant with law. In addition, under multiple other pieces of legislation, including the Young Offenders Detention Act, the Community Services Orders Act, the Domestic Violence Act, the Children's Act, the Children's Authority Act, the Family Law Act, and the Matrimonial Proceedings and Property Act, probation officers are also required to prepare pre-sentence reports for magistrates' courts and high courts, prepare reports for the Court of Appeal, prepare probation officers' reports for all matters referred to the Children's Court, supervise persons on community service and combination orders, counsel parties in domestic violence matters, mediate in maintenance and matrimonial applications, supervise children at risk at the request of the court, submit reports to the Mercy Committee for presidential pardons, submit reports to foreign social service agencies, supervise persons on the bail supervision program, serve the drug treatment court, and counsel walk-in clients from the general public. In fact, according to the Public Service Careers Portal, which is powered by the Ministry of Public Administration and Artificial Intelligence, last updated February 18, 2004, the job summary of a probation officer 1, entailing entrance-level professional work in the provision of probation services, is published online as follows. An employee in this class is responsible for conducting investigations into writing reports and counseling juveniles, family, and others concerned. Work involves interviewing juveniles and adults, writing and maintaining case histories, and attending courts. Examples of work are listed on the web portal, and I would encourage members to peruse the list for details. It is exhaustive. The required knowledge, skills, and abilities are also listed and include knowledge of current economic, social, and psychological health problems affecting young offenders, adults, and family life. It is noteworthy that the entire family, including siblings of the offender, is counseled. Requirements also include knowledge in the interviewing methods and techniques used in eliciting and evaluating sensitive information from persons of various socioeconomic background, ability to demonstrate patience, sympathy, and empathy in dealing with the problems of others, ability to recognize symptoms of maladjustment and determine necessity of referral to appropriate community resources, and ability to deal constructively with aggressiveness, hostility, and other emotional attitudes. Training, as evidenced by a recognized degree in social work or psychology or sociology, with courses in social work or any equivalent combination, is the minimum requirement. Madam Vice President, I have taken the time to highlight the probation officer job summary to place on record that this is an extraordinary and multi-dimensional mandate. These are not single-function administrators. They are, in the truest sense, social workers to the entire justice system, criminal, family, and child welfare combined. The Minister of Justice, in moving the bill, aptly described them as the workhorses of the court system. For 78 years, this service has quietly and diligently served the courts of Trinidad and Tobago as social workers to the justice system. Yet today, it operates in conditions that no one in this honorable chamber should be comfortable with. Let me place before the Senate the current staffing situation with respect to probation officers, because I believe it must be stated unambiguously and placed on the record. There are 55 established posts through the Public Service Commission. There are 41 contract posts, 36 of which are 3-month short-term contracts. The remaining 5 longer-term contracts are all due to expire within the next year. These officers are managed by the Chief Probation Officer and the Deputy Chief Probation Officer. 98% of probation officers are female. I wish the Senate to understand that what these numbers mean in practice. Of the 41 contract posts, which include children's probation officers and community service officers at grades 1, 2, and 3, 36 are currently on short-term contracts. These are 36 dedicated professionals who hold bachelor's degrees, master's degrees, and in one case a PhD, and another working on contracts measured in months rather than years. One of the probation officers is even pursuing a law degree. So these are not low-skilled workers. They are specialists in social work, psychology, sociology, and criminology, which is exactly what this bill requires to implement its expanded provisions. Now, a similar issue is taking place in our education system. And I will quote from Tutor because it explains the impact of short-term contracts. I quote, "The instability of short-term contracts, sometimes lasting just 1 year or even month to month, makes it nearly impossible for workers to plan their lives. Basic financial services, such as home mortgages or vehicle loans, are often out of reach because banks and other financial institutions view contract employment as transient and thus high risk. They are acutely aware that the worker could be terminated at any time. Workers are forced to rely on spouses, friends, or family members to co-sign or secure loans. Beyond the financial challenges, this constant insecurity takes a psychological toll, leaving many workers anxious about their future and their families' well-being." Unquote. The consequence of this precarious employment situation is predictable and deeply damaging. Experienced officers are leaving. They are leaving for opportunities elsewhere, locally, regionally, and internationally. Other Caribbean territories offer better terms and conditions of employment. So we are training and losing talent that we cannot afford to lose. In 2024, there were 1,279 matters referred by the court for supervision by probation officers. I must ask, if we are extending the maximum period of probation from 3 to 5 years, as Clause 6 proposes, and increasing the caseload of every officer, where are the officers to manage this expanded mandate? The last intake of regular officers was in 2018. The last intake of children's probation officers was 2013, 12 years ago. Offenders are becoming younger and younger as gangs recruit increasingly young members. In September 2024, a Trinidad and Tobago Guardian newspaper report by Annalisa Paul, headlined, 8-year-old Gangsters, Cops Reveal Youths Involved in Extortion Rings. Senior Superintendent Richard Smith revealed that several young people were recently held in an extortion attempt in his division, the North Central Division. The description of the 3 persons who went to extort or demand money from a particular businessman was 1 person between the ages of 17 and 22, and 2 around the age of 8 years. We heard from Senator Joan Simmons, who opined in the recent debate on disability legislation that many so-called delinquent children may actually have undiagnosed learning disabilities or may be neurodiverse with associated behavior disorders. I'm pleased to know that the Children's Court has begun using psychiatrists and psychologists to assess children for disabilities. And we must acknowledge that the number of children's probation officers has not kept pace, and this needs to be urgently addressed. An analysis of the volume of matters referred to probation officers by courts between 2020 and 2024 reflects the actual demands on the service that has not seen a significant intake of staff in 7 years. High Court criminal referrals have increased 11-fold, from 12 in the year 2020 to 132 in 2024. Bail supervision referrals have more than tripled, from 120 to 410 over the same period. The number of adult probationers has increased from 37 to 151, while the number of juvenile probationers has increased from 18 to 117. Once the Act comes into operation after proclamation by Her Excellency, both adult and juvenile probationers would naturally be expected to increase in number. Yet the number of officers has remained static. This imbalance needs to be urgently addressed. Despite these conditions, I place on record the remarkable achievements of our probation officers during the 9-month period, October 2024 to June 2025. 1,315 court reports were submitted in the 9 months, and 600 probationers were actively supervised. 491 community service orders were managed, and 591 bail supervision cases were handled. This is the output of a service that is critically understaffed and overwhelmingly female, 98% women, and employed largely on short-term contracts. This Senate and the country owes these officers a debt of gratitude. But it also owes them job security, proper conditions of service, and adequate numbers. I will move now to the bill's provisions. Clause 5 on split sentences enables a court to sentence an offender convicted of an offense carrying 5 or more years imprisonment to a term of imprisonment followed by a period of probation. This is consistent with the approach of the UK Offender Rehabilitation Act, and I support this provision unreservedly. Clause 6 extends the probation period. I welcome the extension of the maximum period of probation from 3 years to 5 years. The international evidence supports this. Breaking the stranglehold of gang influence over an individual takes time. Rehabilitation is not a short-term process. The ability to relocate a probationer's residence, to work with the family over a sustained period to address addiction, unemployment, and educational deficits, all of this takes time. But this provision is meaningless without the staff to implement it. Clause 8 of the bill proposes to amend Section 7 of the Parent Act by inserting a new subsection 4, subsection F, in which the probation order may contain a provision for the probationer to maintain steady employment. How exactly is steady employment defined? If probation officers are themselves employed on short-term contracts, sometimes for as short as 3 months, how are probationers to maintain steady employment? Clause 8 also refers to the quantum of damages and electronic monitoring and non-intimate samples. I note that the data shows that electronic monitoring referrals fell from 95 in 2021 to 86 in 2022, 36 in 2023, and none in 2024. I do not have 2025 figures, but I would urge the government to clarify whether there are resource or procurement issues affecting the availability of monitoring equipment. The new section 15A, allowing offenders to apply to have their records sealed, is a provision I particularly welcome. A criminal record is often a permanent barrier to employment, housing, and social integration. If we are serious about rehabilitation, we must give rehabilitated offenders a genuine, fresh start. Madam Vice President, although I wholeheartedly support this bill, I must also express serious implementation concerns because legislation without resources is aspiration without achievement. Staffing must be addressed immediately. Short-term contracts must end. I call on the government to convert these positions to permanent or long-term established posts as a matter of priority. The Service Commission must be resourced and directed to act with urgency. In addition, the system cannot be addressed in isolation. Probation does not exist in a vacuum. If we are to reduce reoffending, we must address the full continuum of the justice system. I urge the Senate to consider the following questions. What percentage of our prison population is on remand, charged but not yet convicted? How many of those cases will ultimately be dismissed? Should these persons also receive structured supervision upon release? Many individuals become entrenched in gang structures while on remand as a survival mechanism within an inhumane prison system. Bail supervision, not just for those on probation, but for those awaiting trial, must be expanded and resourced. The drug treatment court model has demonstrated success. I have heard of an addict who, instead of receiving a custodial sentence for cocaine possession, entered the drug treatment court process under probation supervision and later obtained a UWI certificate in counseling in addiction issues. He is now a recovering addict, helping to transform other lives. This is the power of rehabilitation. This model must be expanded. I look forward also to the introduction of the parole legislation as indicated by the Honorable Minister this afternoon. I'm pleased to note the establishment in 2024 of the Caribbean Association of Probation and Parole, CAP, a regional organization that aims to standardize probation and parole services across the Caribbean, reduce crime, improve citizen security, and foster collaboration among Caribbean nations. Trinidad and Tobago, with its 78-year history of probation service, must be a leading voice in this regional body. Our probation officers contribute and gain from shared regional experience. Madam Vice President, the numbers do not lie. When 4-year recidivism rates for drug offenders sentenced to prison stand at 82%, compared to 43% for those placed on probation, we are not dealing with a marginal policy preference. We are dealing with a demonstrated evidence-based imperative. The Probation of Offenders Amendment Bill 2026 is a step in the right direction. But let it be clearly understood, the best piece of legislation in the world is only as good as the human beings who implement it. I support this bill. I urge the government to match this legislative commitment with the resources, the staffing, and the institutional support that will allow our probation service to fulfill its mandate for the benefit of offenders, families, communities, and the nation of Trinidad and Tobago. Madam Vice President, I will end as I started, on a reflective note. The holy month of Ramadan reminded us of the power of discipline and compassion. It called us to purify our hearts, to seek forgiveness, and to extend generosity to others. The spiritual Baptists were once told that their form of worship was unlawful. Their story teaches us that systems of law can be wrong, that they can be amended, and they can be reformed. The resilience of the human spirit is capable of outlasting even the most entrenched injustice and forgiving even the worst transgressions. Easter teaches us that forgiveness is not weakness. Forgiveness is the most demanding and transformative act of which human beings are capable. That the person who has transgressed is not permanently defined by that transgression. And that the possibility of resurrection, of new life, and genuine restoration is real. Madam Vice President, these are philosophical foundations of every serious system of rehabilitation the world has ever known. And this is why we are here today. Let us honor these traditions of compassion, resilience, and forgiveness by ensuring that this bill is not merely passed, but properly resourced, faithfully implemented, and built upon, so that men, women, and children who pass through our justice system have a genuine opportunity, not just for supervision, but for transformation. I thank you, Madam Vice President, for having been afforded the opportunity to contribute to this debate.
Minister of Defense.
Thank you, Madam Vice President, for the opportunity to join and to contribute in this debate. Let me start by commending the last speaker on her insights, more particularly those that deal with the social workers, and to give the assurance that that's a discussion I had with the Honorable Minister of Justice some time ago, and he'll indicate in some detail when he wraps up, but we give the assurance that we continue to be appreciative of their efforts, more particularly in the criminal justice system. And because we are painfully aware that our society has too many lawyers and too few social workers and mental health workers and psychologists, that the social workers needn't be concerned, and we are doing our best to ensure that their situation is regularized. Having said so, let me forgive Senator Murray for omitting the Hindu community, because I'm quite certain from what I have seen of Senator Murray from May to now, that it must not have been deliberate. So apart from the Shouter Baptist community and the Christian community and the Muslim community celebrating Shouter Baptist and Easter and Ramadan at this time, the Hindu community is celebrating Hanuman Jayanti and Shivratri. And the beautiful thing about all of these religious celebrations is that there's a central thread that flows through all of these celebrations and recognizes that the most important human quality is forgiveness.
We forgive you.
So we forgive you. The most excellent human quality, as they say in the tradition of Kabbalah. We are at this juncture in a most invidious situation, and let me place it in context. It's an invidious position we find ourselves in because, like it or not, 98% of the persons who enter the criminal justice system and end up in prison, 98% of those persons who enter the prison will be released. Only 2% would never see the outside. 98% at some point will be released. And it's frightening that with 98% of them having to be released at some point, our penal system continues to fail. In the last inspector's report that I know of is one completed by Daniel Khan, then Inspector of Prisons in 2012. And he lamented the fact that the recidivism rate in Trinidad and Tobago far exceeds 60%. And that's a global figure. That's 60% generally. If you disaggregate it and go to certain types of offenses, you see it's a lot higher. Some for obvious reasons. With drugs, the reasons must be obvious. But if we have a system where 98% of these persons who go into the prisons will eventually come out, then we have to take steps to ensure that when they return, as they must, that we achieve two things. One, that when they return, they do not return resentful and bitter, because that causes them to commit further offenses. If you don't equip them, of course, they are back to square one, and that's pretty much the problem. And lastly, if this is the mindset they have when they are released, then the government must balance the rights, the constitutional rights, the sacrosanct rights of the law-abiding citizens to be protected from such persons. So here we are. And before I decimate the gaslighting we were subjected to by Senator Al-Rawi, let me just reflect upon the objects of sentencing, because it is reflected in the bill. Now, it starts off, I haven't seen this case since 28 years ago when I left law school, and it's Benjamin and the Queen, the infamous Manu Benjamin, which sets out the aims of sentencing punishment. So, and in essence, it foreshadows that punishment is intended to reflect the denouncement by the society and legislature, the denouncement of the offense and the offender. That's one. Two, deterrence, the aim of deterrence vis-a-vis potential offenders, so that the offender must be punished appropriately to deter others who are like-minded. So the sentence itself must not only deter him, it must deter others, so that there's an assurance that the particular offender himself is deterred from carrying out this offense, this sort of behavior again. And he's deterred from future criminal conduct by the punishment inflicted by him. And then there's the preventative aspect of sentencing, aimed at preventing the particular offender from offending against the law by incarcerating him. And then there's the rehabilitative aspect of sentencing, which focuses on reform of the prisoner, so that when he returns to society, he returns as a contributing member of society. The next piece of jurisprudence, which relies heavily on these sentencing principles as enunciated in Manu Benjamin and the Queen, is the case of Edwin Fafa. And in essence, it makes the point that the court is best placed to determine which of the sentencing aims should be predominant in the cases that come before it, so that it's not necessarily fixed, but or doctrinaire, but tailor-made, so that in some cases the objective would more or less be, it would be predominantly punishment. In some cases, it might be rehabilitative. It all depends on the facts. It all depends on the offense. It all depends on the offender. So with that in mind, if we, and this answers parts of the contribution of Senator Al-Rawi, if we go to clause 5, and more particularly page 3, and in essence it says probation would be in lieu of sentence, but that's part A, so that a probation order is made, or B, in the case of an offense punishable with imprisonment for 5 years or more, that in addition to the term of imprisonment, there would be a probation officer attached to it on such terms as the court considers just. So let me first deal with the first aspect, where it says, part A, where a probation order is made in lieu of imprisonment. That basically would deal mostly with first-time offenders. Now, you would be heartened to know that the judges in the criminal justice system, more particularly in the last 15 years or so, they've not been too heavy-handed, or the emphasis has not been on sending persons to prison, particularly first offenders and women. First offenders, young offenders, and women are treated very differently for obvious reasons. So we are, in essence, trying to put on a statutory footing what already exists in the courts, because the jurisprudence tells us, in essence, that jail, when it comes to young offenders, first-time offenders, and women, is an option of absolute last resort. So, Part A, in essence, puts on statutory footing the power of the court, particularly for offenders of the class I just mentioned, but even beyond that, it extends it. In appropriate cases, the court would say, they are not going to send you to prison. Because the court is aware, and it's quoted ad nauseum in every plea in mitigation, going right back to 1992, when it comes to youth offenders, when Conrad Duglin in 1992 lamented that YTC is a breeding ground for criminals. So when you send young offenders to a place like that, what do you really expect when they come out, as they must? And when you consider the very high recidivism rate, and you send young offenders into that ecosystem, because those who understand social work would understand the ecosystem's theory, and in essence, a man is not much better than his environment. So if you send him in an environment where he meets up persons from his own community and is able to network with persons from other communities who are already entrenched, all that happens when he is eventually released. And sadly, most times, because our conviction rate is very low, then these measures don't apply to them. What happens when they are eventually released is that they are released onto us as hardened criminals. So these are things we have to keep in mind. But with all of that in mind, what we've done over the last few years, and in our last term from 2010 onwards, we started looking at the criminal justice system as it relates to certain categories of persons. So I was a bit taken aback when I heard Senator Al-Rawi lament about victims' rights and victim impact statements and children in the criminal justice system and how this relates to children who are exposed to the criminal justice system. The first things first, there's a children's court. There's also legislation which details extensively how children are treated when they come before the court. So this bill doesn't need to deal with that, because if you are a child and you come before the children's court, and those who practice before the court would know, again, there are so many measures to protect the young offender from going into the system whilst before trial, and even after trial, so many measures that already exist so that there's no need to make mention of any of that in this bill. In the children's court, they make it clear that restorative justice is paramount, that rehabilitation is paramount, so that those who actually practice before the children's court would know that going to jail is an absolute last resort. And they have the whole menu of options available. Now, the second part, because I just dealt with the A part in lieu of sentence, the second part, B, which deals with persons who get jailed and then have a probation order attached. Well, two things are clear. There's an observance of the sentencing principles, because if it means that a court, having regard to all of the submissions made before it in terms of mitigation, and having regard to the report that must be prepared before sentence is passed, if the court feels that a jail term is warranted, then the court is keeping in mind the punishment aspect, because you must be punished. There are certain crimes you have to be punished for. And since this act deals not just with summary offenses, but indictable offenses, then the gap is the number of offenses that would attract this bit of legislation is now widened. That is a problem we had for many years in the criminal justice system, when judges lamented the fact that their hands were tied as to how they could treat certain types of offenders. And now this, in essence, extends and makes wider the discretion of the court and empowers the court to deal with certain types of offenses and offenders in a certain way. Now, the B, under 2B clause, in essence, recognizes the punishment aspect, but also recognizes that after you serve your term of imprisonment, that you are released to deal with the second part, which is the probation order. So what you have now is hanging over your head, this probation order. So the onus, if you don't want to go back to jail, the onus is on you. And I'm saying all of this because I know that all of the senators here are intelligent and can read and would know everything that I'm saying, but this is really to telegraph to the wider society what this is about. So when you are punished, after the punishment, there is this probation. And the probation does two things. One, the onus is on you. If you do not want to go back to jail, then you comply with the terms of the probation order. If, however, so that rehabilitation and so on, to a large extent is on you. But if you don't want to change your wicked ways and you love the people jailed, then you could continue to do as you please, and we'll just send you to complete the rest of your sentence. So, in essence, the sentence is ambulatory in the sense that it's hovering above your head. The threat of serving the rest of your jail term hangs over your head and is all on you. But if you, with the help of all the other mechanisms, if you are able to turn a new leaf and to walk the straight and narrow, then you don't go back to jail, and you can even at some point make an application to the court so that your records can be sealed. So, there's merit, first of all, in extending the types of offenses and offenders who can benefit, the offenders who can benefit and what types of offenses. But it also, in essence, increases certain things, like the 3 years obviously would not have been sufficient. It has now been raised to 5 years. And before I go on, it makes me remember one of my prisoners, hardened criminal, who always complained about the high recidivism rate and the fact that the prison doesn't have anything for him, and he basically threw his hands up and said he cannot change. And had to tell the magistrate that he has been in and out of jail since Big Bird was a hummingbird. That's something I'll never forget. But now, when you look at the bill, you see that there are aspects of the bill that allows for proper monitoring, that allows for the protection of the law-abiding, that allows for the gathering of evidence, that allows for the protection of victims. I can go through, I think it's clause 8. And it deals with the probation orders that the court make. And one of the things is, in essence, participation in community service, which was one of the things that was mentioned by Senator Vieira earlier. So it doesn't exist in isolation, because at present, the Community Service Orders Act applies only to certain offenses, and there are serious limitations, so it's expanded. So you would have to wear an ankle monitor device that, in essence, allows us, or allows the government to basically know where you are. It would allow us to know if you are in breach of your probation order, and if you are in breach of the order, then back to prison you go. Again, that's on you, the offender. The letter D, the taking of non-intimate samples, reference was made to that by prior speakers, because two things: it allows us to know if you are complying with the order, because the order might be that you should not smoke weed, which is, I don't know if to thank them or to curse them for it, but the legacy of the last government, their crime plan was free up the weed, let everybody get high. That's their crime plan. So we are seeking to roll this back, because that's not much of a crime plan. We all know what happens when you smoke weed. In the initial phase, it's world peace for 1 hour, and then in your refrigerator, after 2 hours, there's a food shortage. You eat everything inside. And then the next day you wake up late and you can't go to work and you lose your job. There's very little positive about that. But that was their crime plan. Because I've heard so much about root causes, and it's quite clear. I'm not going to go into it today because the Attorney General told me to be civil and not to share licks. But it's quite clear they do not understand the difference between proximal causes of crime and root causes of crime. I looked both at their 2015 manifesto and 2020 manifesto, and the one thing they demonstrated is a fundamental misunderstanding of how you deal with the root causes of crime. Substance abuse is one. So you can't have people smoking marijuana in their house in front of their children and then be surprised when what monkey say monkey do. So let me go through again. So D deals with monitoring those who are using drugs or alcohol in violation or non-compliance of their probation order. But it also allows the person under the probation order to clean up his act so that he'll know, I can't smoke weed, I can't, even though it's legal, I can't use alcohol. And eventually, you are cold turkey, you are clean. Because a lot of the problems we face in this society, we face as a result of smoking weed and drinking rum. I remember campaigning and all you were seeing, punching flowing like water. Fight, lasciviousness, we have to get rid of that. So we have to help the probation person to clean up his act. And if he doesn't, if he's caught in violation, when the sample comes back that it's more punching than white blood cells, then he'll know that he has to go back to prison. More weed, go back to prison. E, that he has to participate in supervisory programs. F, maintain steady employment. G, the pursuit of education and training and so on. H is very important, that he resides in a particular geographic area unless there's written permission to go outside of it. It protects more particularly victims. I, letter I think is one of the most important, and which goes towards, it's a ZOSO type measure, because it deals with having this probation prisoner abstain from communicating directly or indirectly, not just with victims or witnesses, but other persons identified in the order. And the orders could be quite wide, preventing you from going to certain places, geographic areas, and so on. And as the court considers necessary. So that this provision is wide enough to allow a court to say, well, here's what. We know that in jail you networked and you networked with members of the 6 or members of the 7 gang. So that part of this order, part of your probation order is when you leave, if you don't want to end up back in the people jail to hug up a boy or whatever else, then you do not go and associate with members of the 6 or the 7. We are in essence, this is in essence what, yes, it's a restriction on movement, but the connected aim is that you protect them from being reintegrated back into the gangs that sent them there in the first place. They like the Agapa boy business. That you were a priest, you shouldn't be laughing at that. Right. And of course, well, K is obvious, and L, comply with such other provisions. Again, it gives the court a very wide discretion. Such other provisions that the court considers necessary for securing the good conduct of the offender. Now, 9 and 10. This takes me back to something Senator Al-Rawi said, and it really baffled me. Senator Al-Rawi said, why don't we change it to from the time he commits an offense? Jesus Christ. Why would we do that? Isn't there something called a presumption of innocence? Because the minute you can't be in violation of your probation officer by committing an offense, because there's a presumption of innocence. You could be set up. You could have an explanation which would show that you didn't actually commit an offense. You could have been acting in self-defense. All of these things. So why would we put the minute you are found committing an offense? And you know, if we had put that, he would have been the first to stand up and say, what about the presumption of innocence and surat and suraj? Yeah. There's no pleasing them with everything. 1 minute, they have a problem with the radar. Well, the radar gone next minute. Why the radar gone? Bring it back. 1 minute, they want to criticize my friend Mr. Zaku about the fines, for the traffic fines for serious offenses designed to ensure compliance. And the next minute, Senator Al-Rawi is saying, why shouldn't the fine be 250,000? Why 3,000? Make up your mind. What does you really want? What does you really want? Surat and surat. Right. You know what? I think the bill would be online. I think people could read it. Let me not spend too much time because I want to deal with some things Senator Al-Rawi said that I found quite frankly shocking. He says, why not bring the parole bill first? Let me not waste too much time, but just ask him to harken back to section 2 of the bill, which speaks of a proclamation clause. Because there's no prejudice to anyone by bringing the bill now and having the parole bill dealt with in the House, and then at an appropriate time, when all systems are in place like any other piece of legislation, at that time you proclaim it. That's why there's a section 2. Section 2 makes it clear that there will be a proclamation date. This act comes into operation on such date as is fixed by the President by proclamation. So it dismantles that fig leaf of an argument. Then I heard, well, this one I can forgive him for because I know how he got silk. He has the ability to speak for 45 minutes and say absolutely nothing. That's a skill. But it couldn't be for being in a court. I'm sorry, AG, I was supposed to be civil. Last one. Because Senator Al-Rawi said that you have to factor in preliminary inquiries when dealing with this bill. The Probation of Offenders Bill deals with punishment. Punishment, dear sir, comes after a trial. A preliminary inquiry is a hearing to determine if there is sufficient evidence to put you on a trial, at which time then you'll either be acquitted, and if not, and you are convicted, only at that point does the Probation of Offenders Act come into place. For God's sake, what does a preliminary inquiry have to do with punishment? If it comes long before trial, first, and secondly, if preliminary inquiries no longer exist.
Standing Order 42-9, please.
That's if the member is willing to.
No, I'm not willing to give way.
For you to make the decision as to misrepresentation, allowing me the time after. It is not for him to give way, madam.
After it, let the member continue.
Much obliged. Thank you.
So, I don't know why he mentioned it when preliminary inquiries have been abolished. And then he'll tell you, well, you have to factor in the fact that it was abolished. It wasn't relevant in the first place, whether you abolished it or you didn't abolish it. It was of no relevance. That was simply filler. You know, you run out of things to say in an exam, and you write all you know about a particular topic. That was an example of that. Then he says, why are we stopping at sealing? It should be expunged. But you know, if we did come and say expunge, he would have said, no, that's going too far. Seal it. But of course, we all know the benefits of sealing. That was made, that was referred to just now. Oh yes, he said fine was too low. He wants it at 250,000. So apparently he's abandoning the narrative his party has that fines are too high. Then he says the court ex proprio motu should vary the probation come on. The court is an independent arbiter. How could the court ex proprio motu initiate proceedings to vary the order? It has to be the probation officer to come and complain and say vary the order because he's not complying, or because you have to make it a little easier, or something. It has to be a party to the proceedings. It has to be the person under probation to come and say, look, these things too hard. The curfew too hard, the electronic monitoring too hard, whatever. Or the probation officer to come and say, vary it for whatever reason. How could the court, 4 more minutes, how could the court, on the suggestion of Senator Al-Rawi, say that they should be the ones on their own volition? Jesus Christ, that was a twilight moment. Sorry, I promise to be civil. Right. And then about the registrar, or the probation officer might know how to follow the form. Come on. There are people who can't read and write. When they reach the court does help them follow the form. You could tell me a social worker would know how to fill out a form? Then he complains about the Commissioner of Police should have access to a register so we know all who are on probation. Oh God, please. The Commissioner of Police has access to the Criminal Records Office and the CAPA database. And the CAPA database would have the names of everybody, including the CRO, Criminal Records Office, would have the names of everybody who get charged and convicted and what the sentence was. So if you're sentenced to probation, what other problem you're creating some other register when the Commissioner of Police already has access to do it? This again is another instance of write everything you know about a subject because you did the study for it. Right, I dealt with the part about the children's court. Oh God, victim impact, Senator Al-Rawi, the courts, the people who practice in the courts already know that the courts, even without the statutory underpinning, they ask for victim impact statements. And that is bizarre, having regard to the fact that we already tell you that a bill coming to deal with that. But you want to fit everything in this bill. So we're going to leave for the victim impact bill when it's time to bring it. And then, where's this one? Something about 2 years, and bring it forward, and I don't know. Nah, you can stay. Dog eat shame. Right, and he talked about, well, you can't tell us about root cause letters. Let me just wrap up with that, because the root causes, when you're dealing with the root causes of crime, the result is 10 years on the road. So whatever root causes you dealt with, but you didn't deal with it in 2015, we feeling the effect of it now. So your plan to deal with root causes of crime would have been 10 years ago, proved to be an abject failure. All you are good for is to come here and give us rubber talk, and to have us gaslighting us, jumping from one foot to the next, do this, and if you do it, no, do this instead. That is your plan. So you do not have the moral authority or the experience to lecture anybody on crime. Can I ask how many minutes? So I can finish the mopping, or just seconds?
7.
Oh, God. Well, I thank you. It was a pleasure, and I'll go home now and watch on my TV. Thank you.
You have 2 minutes, Senator.
Thank you, Madam President. In relation to Standing Order 42.9, I rise to explain. I certainly did not make any contribution about preliminary inquiries. I addressed the position of a JIPA and the method by which you go to court, and you are first brought there. There's a gross misrepresentation and misstatement of what I said, and I certainly could not be speaking about any expertise in crime. That is for my friend Wayne Sturge, and there will be more to be said about that in due course.
Senator John Bates. Sit down.
Madam Vice President. Madam Vice President. Madam.
Okay, members. All right, let's continue. Senator John Bates.
Madam Vice President, I thank you for the opportunity to contribute on this very important bill. This bill comes before us under the banner of strengthening probation and enhancing rehabilitation within our justice system. The amendments contemplated therein expands the conditions of probation, extends the duration of probation, and also extends the consequences for a breach of probation. These objectives, on the face of it, appear commendable, entirely so. But, Madam Vice President, good intentions do not automatically produce good law.
As legislators, our responsibility is not simply to agree with the aim of a bill, but we are called to interrogate whether the mechanisms chosen to achieve these aims are workable and consistent with established legal principles. The question for the Senate, Madam Vice President, therefore, is not whether we support the enhancement of the Probation of Offenders Act. I'm sure we all do support such a cause. But the question is whether the amendments as proposed will achieve and actually deliver what was indicated as the aim. In this regard, I propose to examine 3 areas. I propose to examine 3 key areas. The legal definition of the term of imprisonment as proposed by the bill, the legal and practical challenges arising from the provisions that are introduced by the bill, and whether the state has the capacity and resources to make the framework work in practice. Mr. President, traditional probation is a sentencing option used for carefully selected offenders where the court conditionally suspends their punishment and the individual is placed under supervision with guidance and support aimed at rehabilitation. Our Probation of Offenders Act, as it currently stands, adheres to that traditional definition. Under Section 3, as it stands, probation operates as an alternative to imprisonment, and that operates whether it's a summary offense or an indictable offense. The court, having regard to the offender's character, their criminal background, their home, and their health, may choose probation instead of a custodial sentence. And that is in line with the United Nations Standard Minimum Rules for Non-Custodial Matters, also known as the Tokyo Rules. Mr. President, the bill changes that. The bill now allows for imprisonment followed by probation. That represents a fundamental shift in the philosophy behind our Probation Act as it is. We are now moving into a split sentencing regime so that probation is an extension of custody. I would posit we are now moving the pendulum away from rehabilitation, which the minister, he focused on a lot in his contribution as he piloted the bill, towards retribution. Mr. President, if that's the policy of the government is within its prerogative to undertake that shift. Split sentencing has its pros. The government would have outlined the fact that it would introduce some flexibility. It would expand the pool of offenders who may be subject to probation. But my question is this. The government would have also indicated that they want to introduce a parole system. The parole system, because I had a sneak at what the government proposed, has a sort of split sentencing regime in there, or something akin to it, something that would achieve the same goal or the same end. So my question is, what is the utility of bringing this amendment now if we are moving towards a parole system where a person would serve a custodial sentence and then be let out with supervision? I can envision that a lot of judicial officers would tend towards the parole system if that bill is successfully passed and that act is proclaimed. So again, I just question the utility of introducing that split regime or something akin to it at this juncture. Now, I want to move on to something of critical legal importance as it relates to this bill. The bill speaks to term of imprisonment. Subsection 4 says that for the purpose of subsection 2b, term of imprisonment means, and then you go to B1, in relation to a person serving 2 or more concurrent sentences, 2/3 of the aggregate of those terms. Mr. President, when sentences are said to run concurrently, they run together. You don't aggregate them. In fact, what happens is that the offender serves the duration of the longest sentence. That is a well-established principle of sentencing, grounded in fairness and totality. This bill requires something different. This bill requires that the offender serves 2/3 of the total of the sentences. So this would result, sometimes, it could result in that the offender spends more time in custody than he would normally do under normal sentencing principles. Some simple maths can highlight that. If an offender on indictment is found guilty of 2 offenses, he's sentenced for 4 years in one, 5 years in another, he would spend 5 years, the longest one. If we had to aggregate the 2, 4 and 5 is 9, 2/3 of that is 6. So if he was a person who would have been found to be suitable for probation, he would actually have to serve 6 years before he can be released on probation. And this is not something that is far-fetched that can happen. I had a look at a case on Webopac, a case of State and Josiah Job, also called Ryan. On his first indictment, he was sentenced to 4 years and 2 months and 10 days for possession of firearm. He was also sentenced to 4 years, 2 months, and 10 days for possession of ammunition. And the sentences were said to run concurrently. So he would actually spend 4 years, 2 months, and 10 days in prison. Now, if he was someone who was found to be suitable for probation, the court would then have to, what would be required is that you add them together, and you'd actually get 8 years, 4 months, and 20 days. And 2/3 of that is 5 years, 6 months, and 13 days. So he would be required to spend more time with this law than he would normally have had if he was someone who was suitable for probation. And I'm not saying that this is a person who the court would find suitable for probation, because I don't know anything about this man's character, antecedents, home surroundings, health, or mental condition. I'm simply saying that to require someone to serve 2/3 of the aggregate of concurrent sentences, as opposed to consecutive sentences, can have an absurd result, namely that in order to be considered for probation, his term of imprisonment would exceed the sentence actually imposed by the court. Now, Mr. President, another concern I have with this bill is that some of the conditions imposed therein are a bit vague. Now, if we look at Clause 8 of the bill, it introduces a new Section 7.4, which empowers the court to impose a suite of specific conditions, including maintaining steady employment, actively pursuing educational, technical, or vocational training, and actively participating and cooperating with a program of supervision. Now, Senator Vieira would have described these conditions as modern. At a first glance, they may appear reasonable. But, Mr. President, those terms are not clearly defined. They are expressed in very broad and aspirational language. But a breach of any of them can trigger a very serious consequence. Mr. President, the Tokyo rules state that the conditions to be observed shall be practical, precise, and few as possible. Do these conditions, as proposed by the bill, meet these standards? Are they practical? What does maintain steady employment mean in law? What is the standard to be applied? What is a probationer to expect that means to him or her? Let's consider it on a practical level. Let's think about a self-employed tradesperson, a carpenter, a plumber. Their work is inherently intermittent. They have high seasons, Christmas, Diwali, etc., and then you'll have some lulls. So at what point does the natural fluctuation become a failure to hold steady employment? Is it 1 week between contracts, 2, 3, 4? See, Mr. President, this is a classic example of the Sorite's paradox. At one point, at what clear point does something cease to be one thing and change into another state? At what point does your working condition cease to be steady? Law demands certainty, and that condition is not certain for anyone to understand. This government has also created a volatile economic environment where thousands have lost their jobs. They are unable to secure employment despite months and months of applying. No amount of job fairs and websites have aided any of these individuals. In that sort of environment, maintaining steady employment may not be something within the probationer's control. It's not a matter of their willingness, but a matter of opportunity. In a similar vein, Mr. President, we have the provision that the probationer should actively pursue educational, technical, or vocational training. And that provision may be equally impractical given our economic climate. What does actively pursue training mean? What does it require? Especially in circumstances where these programs are now limited, oversubscribed, or inaccessible due to cost. Mr. President, prior to April 2025, young people between the ages of 16 and 35 had access to a plethora of courses, free courses, through the Ministry of Youth, Development and National Service. They had training in coding, web design, hair braiding, carpentry, construction, heavy equipment operation, music production, farming, and much more. They could pursue virtually any technical or vocational skill at little or no cost. As my colleague just said, what I know. There is a clear dearth of these available and affordable programs for youths. And Mr. President, in my practice, it's clear to me that most individuals who come before the courts as offenders, most of them, do not have the means to engage in a variety of courses offered in some other institutions. This bill, therefore, creates legally enforceable obligations based on terms that are not clear and, in many cases, not achievable in our current national context. So that raises a fundamental rule of law concern where obligations are unclear, thereby risking enforcement being inconsistent and sometimes arbitrary. Another concern I have with this bill is that the amendments may not be workable if there is not an increase in capacity. Now, let's take a look at the probation officers, for example. Senator Murray gave us an extensive exposition into their role and their current conditions. So half of what I have to say I could eliminate. But I would say that at the Ministry of Homeland Security's website describes probation officers as social workers to the courts of Trinidad and Tobago, assisting in the rehabilitation of persons who have come before it as a consequence of breaching the law. Now, from my time in prosecuting offenders, I can say that the probation officers were really a critical feature and the backbone of our criminal justice system, especially at the sentencing stage. Judicial officers, I think, bar none, they request a probation officer report before they engage in sentencing. And these reports are not slapdash, not one page. They require extensive research and meeting with a variety of individuals so that the court could have a clear understanding of the offender's background, their family environment, and their prospects for rehabilitation. So the scope of work of a probation officer is very extensive because they are not only involved in the criminal justice system, but their work extends into the family and children division as well. They provide numerous reports for those under that system as well. So their work is extensive, multidisciplinary, and demanding. Now, the amendments proposed by this bill will exponentially increase the workload of these probation officers. It expands both their responsibility and their accountability, and we have not been presented with any visible expansion of their institutional support. The number of provisions, for example, the number of provisions that a probationer could be subjected to has been expanded by the bill. The court can now place the probationer under a curfew. The court can order that the probationer give a non-intimate sample to the probation officer. The court can order the probationer, as I said, actively pursue education, abstain from communicating with witnesses, and so forth. So that the supervision and monitoring that probation officers would have to undertake, as I said, would be expanded. In order for them to detect breaches, what they monitor, how they monitor, and the frequency of monitoring would have to intensify. Further, if the probation officer does identify a breach, they'll then be required to undertake the additional step of laying a complaint. That's something very new. They're now moving from a supervisor and monitoring into enforcement. Section 10 of the bill amends Section 10(1) of the Probation of Offenders Act and now authorizes a probation officer to lay a complaint before the court where the probationer has failed to comply with any of the provisions of the probation order. This necessitates them making contact with a justice of the peace, much like a layperson, at the district court, and laying a complaint, as I said, similar to, I suppose, like a private complaint. But in addition to laying the complaint, that would then mean they would have to attend court on each and every occasion that the matter is called. And if you have any involvement in the criminal justice system, you know matters are getting called once, twice, 3 times. There's a number of times over a number of years. So that takes away from the time that these probation officers would usually use for other tasks. Their report writing, for example. Everything that they would have to do towards ensuring rehabilitation of the offender would have to take a back seat to them attending court. And the resource gap doesn't only stop with the probation officer. The new Section 7(4) of this bill also allows, as proposed by this bill, also allows the court to order a probationer to wear an electronic monitoring device. Now, this is in keeping with Section 10(2) of the Administration of Justice Electronic Monitoring Act, number 11 of 2012, which empowers the court to impose electronic monitoring as a condition of probation. So while the law allows electronic monitoring as a condition of probation, in my experience, I am not really aware of any court making such an order pairing them together. Perhaps they have, I'm subject to correction, but I don't think it's a usual order made. But if we want the court to start regularly imposing electronic monitoring as a condition of probation, the government would need to increase the number of electronic one-piece devices available. These one-piece devices, as we colloquially know them as ankle bracelets. Currently, there are 300 ankle bracelets and 50 home detection units. Each of these ankle bracelets and home detection units, or home confinement units, I'm in detention, home detention units or home confinement units. Each of them costs approximately $10,000. In the 2025 to 2026 draft estimates, the electronic monitoring unit was only allocated $500,000. And that is insufficient to address their recurring needs and buy more equipment. So the electronic monitoring unit needs more funding if it has to expand. Additionally, expansion of the program to allow for the use of electronic monitoring in probation would likely require more staff. You need more shift monitors. So the insertion of electronic monitoring as a condition is welcome, but I would call on the government to ensure that the electronic monitoring unit has adequate resources to fit offenders with these ankle bracelets and to effectively monitor individuals if such an order is made. Now, Mr. President, before I wind up, I just want to take a few moments to address what the last speaker, the Honorable Minister of Defense, who has, I don't want to say run away, he said he went home. That shows the importance that he has placed on this debate. But the Honorable Minister, he said one thing I agreed with, one critical thing, he said, a man is not better than his environment. And I had to agree with him because when I see the environment he's in, I could understand why his debate would descend from an analysis of the amendment into insults. Can't help himself. He can't help but be acerbic in his nature, given where he is. But he went down a road, and I don't know, those on the other side have this love affair with Senator Al-Rawi. He went down this road into insulting Senator Al-Rawi and misquoting him instead of focusing on what he had actually said. The goodly senator actually stood and clarified a few of the points, so I don't have to go there. But one thing I would expect that the Minister of Defense would know is the difference between decriminalization and legalization. He stood here to say that those on this side, the crime plan we had was free the weed. And I guess to say that was a failed crime plan. But if you want to talk about failed crime plan, talk about the SOE that is currently in place. That's what I want to tell the minister. And I'll leave it there because the rest of his contribution deserves no comment. Now, Mr. President, back to the bill at hand, which, as I said, there are some commendable aspects. The bill undoubtedly seeks to strengthen probation. It expands the obligation, it extends supervision, it increases consequences. But to be effective, attention needs to be paid to clarity, consistency, and capacity. If we are to build a probation system that truly rehabilitates, which the minister really focused on, then it must be one that people can realistically comply with, that officers that can effectively supervise, and that the law can clearly define. Otherwise, we risk creating a system that looks strong on paper, but fails in practice. And with that, I thank you.
Senator Wesley Gibbings.
Thank you very much, Mr. President, for this opportunity to rise in support of the Probation of Offenders Amendment Bill 2026. But at the same time, to register what I would like to describe as a few reality checks. Because I don't think there's need for any more legalistic pedantry on the issue. We've heard quite a lot of it this afternoon. Not to decry that in any way. It's not my professional discipline, and I have high regard for people who can engage at that level. But on this occasion, I don't think that there's much more of that that's required. Neither do I think it incumbent on me to regurgitate any of the well-informed commentaries and observations regarding the value of probation. There's no doubt about it. There's high value in it. And the minister has also gone so far as to locate the measures in this bill within the context of a suite of laws. So it's not just this. There's a lot more to come. And we should all welcome this, but at the same time recognize our partial for implementation deficits. The how, the what is clear. And Senator Murray went into some detail regarding the deficits that we are likely to confront when it comes to implementation. Now, from the very beginning this afternoon, I thought that this conversation could have begun because much earlier, during the question time, we spoke about the rights and responsibilities of children and the protection of children. And perhaps if we were to frame this debate, we could have begun at the very start, at question time, when there was expressed concern for children, their rights, their protection, because things really start there. From my vantage point, there are key contexts that need to be fed into consideration of this bill. Because for sure, the incidence of recidivism has already been substantially addressed. Nobody has disagreed with that. And in fact, the 2020 study cited by the minister in his introduction of the bill is very instructive. But because they basically concluded that Caribbean-wide, the average is in the vicinity of 41%, which is pretty serious stuff. I would be interested to see, because that study was conducted, I think, between 2018 and 2019, and the report was completed in 2020, this is in the pre-COVID era. I would like to see what would be the result of a study now in 2026 going forward. We might be looking at a completely different set of data to analyze. Now, what is clear from all of this, if we look at it in this way, recidivism, the role of imprisonment, and so on, we can conclude quite safely that more jail don't mean less crime. That it has not worked that way. More jail doesn't mean, does not produce the kind of preventative measure that's required to keep crime down. Now, don't make no mistake about it. If you commit crime, you need to be punished. And imprisonment is one form of punishment. The bill establishes that, but it provides an option, albeit a second option. So probation, in the context of the bill, is secondary to imprisonment. So is it clause 5? Provides the option of probation in addition to or in lieu of a prison sentence. So there's still an express preference for jail. Jail them, lock them up. Which leads me to the next part of my observation, or the other reality check, which is the fact of inequity in our society and our socio-economic circumstances. We are also living in a time when the country operates as if we're under siege. Whether we express it in measures of states of emergency or other measures, extreme measures, there's a perception out there that we're under siege and something needs to be done. Lock them up, kill them even. So there's an interpretation of contemporary legislative interventions, which is that it provides pathways for locking them up, putting them away, killing them even. And that's a sad, sorry state of affairs in my view. It is the kind of situation that has produced pervasive fear, grief, and most of all, and most dangerously, anger. It is the kind of situation that leads to revenge being mistaken for justice. You know what I'm talking about? The notion of an eye for an eye, which invariably results in states of national sightlessness. And we're headed there, unless we intervene. Now, the bill can be interpreted as one of those measures that would provide us with options on this subject of punishment or righting wrongs that are occurring in our society. But let's make no joke about it. Let's not be in denial. Our current circumstance is one in which people feel that we're under siege, we're in danger, people are fearful. There's abundant grief. You look about, I'm in the field of journalism, and we confront this on a daily basis, all the time. There are people in grief. And as the product of this is this anger, so we need to, in my view, as leaders in our society, generate messages of hope. Messages that suggest that we have an understanding of what people are dealing with. In that context, the bill is very relevant because the bill is concerned with a notion of restorative justice, which is a guiding principle, and it must form an indispensable feature of all the interventions when we deal with addressing the problem of crime. So we don't just stop at punishment, We take aim at issues such as addressing the harm caused to individual and community victims, and that point was made earlier by Senator Al-Rawi. And it's not to be ignored that the harm caused to individuals and communities need to be included in this notion of restorative justice. In fact, it's implicit in the notion of restorative justice that there is a concern about the people who have been victimized, the rehabilitation of offenders, and the collective efforts of the entire society. Then we also need, I think, in the entire package of interventions, consider the impact on economic opportunity and communal integration, the integration of those people who have gone through the system and who have been punished and who have been prepared. And again, we have to be concerned about the implementation deficit and the role of probation officers and other professionals. This is not just a matter for police, lawyers, court, and jail. I said at the very start, I suggested that I would be mercifully brief, so I'm going to end on this point, which is good that these measures have to be recognized as just one component of a far-reaching suite, not only of legislation, but other kinds of social interventions to address some of the fundamental challenges that we face as a small developing country. But this bill, as I said, enjoys my support, and I get from the Assembly today, enjoys the support of others, but we need to recognize this as one very small but significant step forward on this issue. I want to thank you very much.
Senator Sanjiv Boodhu.
Thank you very much, Mr. President, and I too will be mercifully short, as my colleague has said. But first, permit me to place on the record my gratitude to you, Mr. President, for permitting me to join the debate this evening, and of course to the political leader and leader of the opposition, Mrs. Penelope Beckles-Robinson, for giving me the opportunity to stand here once again this evening to contribute to what I consider to be, what the opposition bench considers to be a very important piece of legislation, or amendment to a piece of legislation. Given the fact that my colleagues have taken the time to go through, on all sides, go through the bill almost clause by clause, I'll take a practical approach to things and attempt to wrap up as quickly as I can. Mr. President, this bill proposes to amend the probation framework, as it were, to empower courts to sentence an offender to imprisonment and to a period of probation, that sentence being pronounced all at once, together. And I wish for us to take a moment to understand that. You see, the court has found someone guilty of an offense and is saying at the point of sentencing, you are sentenced to some time in jail, after which you will come out of jail, return to the community, and under the supervision of a probation officer. And that is what the bill fundamentally says in terms of its amendment to the current state of the law. That current state of the law, Mr. President, as it stands, is where a person is charged with a summary offense. And for the benefit of the listening population, a summary offense is one such as an assault or simple larceny, obscene language, that sort of thing. Where someone is charged with that type of offense and it appears to the court that the offense is made out, or it appears to the court that the person charged is likely to be guilty of the offense, the court may consider whether that person is fit for probation. So in considering that, the court has to take into account the person's history, their background, their family situation, their living arrangements, their occupation, their logistical environment, their criminal history, very importantly, their health, their mental status, the nature of the offense for which he is charged, and the extenuating circumstances, such as the effect of the alleged offense on any victim, the prevalence of the offense in society, and the accused or the accused's propensity to re-offend, or how likely he is to commit another offense. And having regard to all of that, the court may find that the person should either be convicted but made subject to a probation order and therefore practically be spared jail, or not to be convicted but to be subject to a probation order, in which case he or she is also spared jail and in that case spared a record of conviction. That's at section 3(1) that deals with summary offenses. But either way, Mr. President, the effect is that the accused avoids jail and is released back into society under the conditions of the probation order and under the supervision and reporting of the probation officer to whom he or she is assigned. And currently the state of the law is that that's for a period of a maximum of 3 years. Now the government here in this bill proposes to extend that maximum period to 5 years. What the bill now introduces into the current framework, aside from that extension, is where a person is charged with a more serious offense, an indictable offense. An indictable offense is one such as a home invasion, possession of a firearm, a shooting offense, kidnapping, extortion, robbery with violence, assault occasioning actual bodily harm. That means an assault that causes an injury, a rape, other sexual offenses, where somebody is convicted of one of those offenses, which is called an indictable offense. Convicted meaning they are found guilty beyond a reasonable doubt, is found by the court as a matter of fact to have committed the crime for which he or she is charged. The court may either not sentence him to jail and make a probation order, which is the current position, or by this amendment, the court may now, if the offense carries a punishment of imprisonment for 5 years or more, sentence the person, 1, to imprisonment, and 2, to a period of probationary supervision and reporting after he has served the term of imprisonment. And the further part of the amendment, or the further amendment raised by that part of the bill rather, introduces certain calculations as to how much of the sentence in terms of time the convict is to spend in jail. Now, where the bill says where the conviction is for one offense, it is half of the sentence. That means that you're brought before the court on an offense that carries with it a 5-year maximum or more. You are sentenced and you are required to spend half of that sentence in jail and whatever the probationary period is thereafter. But where there are multiple convictions, where you're charged with 3 or 4 offenses, let's say, that calculation becomes 2/3 of the sentence. Now, as identified, there is an error, respectfully so, or that is my opinion. There is an error in the drafting in relation to how that is worded, because you cannot speak about an aggregation of a concurrent sentence. Aggregation and concurrent are 2 opposing words. They mean the opposite thing. So that has to be fixed, and I'm sure the learned minister would agree with that. But let us consider what it practically means. All of this practically means for the convict, for the court, for the victim, and for the citizens at large. 4 categories of people. Now, to the convict, Mr. President, it means that someone found guilty of a crime is able to suggest to the court, usually through their defense counsel, with the support of a probation officer's report, if that is ordered, that he or she should spend less time in custody in favor of some more time in society under supervision. That's the declared intention of the bill, according to the Honorable Piloting Minister. Now, the next category, the court. What does this mean for the court? As the law is currently set out, the court can consider a probation order, but in practice, currently, it seldom or rarely does so, especially for serious offenses. That is because right now, the state of the law is that there are no minimums, including in the existing legislation. It is either the convict is sentenced to jail or is released on a probation order. So the court would be and is currently slow to place someone on a probation order and not in jail, especially for a serious offense, as the bill says, carrying 5 years or more. So Further, the court in sentencing always has a responsibility to balance things. They have to balance the public interest, which is the interest of deterring persons from committing crimes, and punishing those who cannot be deterred and are bent on criminality. You have to balance that public interest with the convict's right to fairness and equality before the law and to proportionality in sentencing. You have to balance that second category with the interests of the victim who has suffered a significant human indignity of being victimized by crime and who may have suffered actual bodily injury, actual mental anguish, actual financial loss, and all of the detriments of being the victim of a crime. So in striking that balance, the court, as the law currently stands, is unlikely to order that a man convicted of a violent crime should be spared a jail sentence and be put out on the street, so to speak, under the supervision of a probation officer. But what this bill does is it introduces a duality in sentencing options, or as the learned minister said, a split sentencing, which is the correct terminology. It invites the court to sentence the violent convict to a period of time in jail and a period of time outside of jail under supervision and under certain conditions. By giving the court this option, the government obviously intends that the court makes use of it. The only way the court can realistically make use of this option is to use it as a factor by which a jail sentence is reduced. It is irrational and illogical and clearly not the declared intention to think that the government would suggest that the court would impose a jail sentence and on top of that impose a 5-year probationary period. That's not the declared intention. The declared intention, clearly, as we've learned from the progress of the debate, is to cut short the jail sentence in favor of some time outside. So that question is settled by the Minister of Defense making reference to the government's position as, quote, compassionate and open to, quote, second chances. So the intention is clear. Now, the mere fact that the government has extended the maximum period of probation from 3 years to 5 years also tells us clearly that their intention is to guide the courts towards a probation order and away from extended sentences to encourage a sort of trade-off, reduce jail in favor of probation. And this is consistent with the introduction of the calculations as well, where they say you will only serve half of the sentence or 2/3 of the sentence and come out on the probation. Now, so far in the debate, Mr. President, we have accepted that this bill is part of a crime-fighting and criminal justice reform policy of the government. And it is an important and useful bill, and it is clearly intended by the government to positively impact on the crime situation. But the big question that therefore arises out of that is, how does this intention to reduce jail times for convicts saddle with the fact that this government has declared to all of our citizens that crime is so badly out of control that we, the citizens, must be subjected to a suspension of our constitutional rights by the implementation and extension of now a second state of emergency in less than 12 months. How do those things run at the same time? The current crime situation, according to the government, is at a critical point. That much is obvious, Mr. President, if you look at any newspaper over the last few months. In fact, while we were sitting here in the Senate this afternoon, I saw a media reporter sharing a story that an alleged bandit in the El Socorro area was shot by somebody who owns a legal firearm, as it were. Now, the point about that is that happened in broad daylight while we were sitting here in the Senate. So it is clear that crime is out of control. Citizens are concerned now more than ever. Men, women, children, including an 11-month-old baby, are falling victim to brazen daylight shootings. And so the government has said that the only way, literally the only way, to get a handle on things is to declare that a state of affairs in Trinidad and Tobago is at emergency proportions. Because that is what a state of emergency is. It is a declaration, an announcement, an admission by the government that we are under imminent and urgent threat and our survival is at risk. We must act immediately, is what the government is saying. We must act without due process, without warrants. We must suspend rights. That is all in order to take control of an out-of-control situation. Yet in the face of all of that, we have all of that SOE limitations on rights in existence. We have the most violent crimes being committed with impunity. Murders, robberies, shootings, extortion, kidnappings. And on the point of kidnappings, we are now back to the random kidnappings, which worry the citizens more than anything. There is the kidnappings that are happening now. There's not the big money, $100 million ransom kidnappings, or the kidnappings where there's some allegation of an underworld connection. This is the kidnapping of a retiree from a house, from her own house, by alleged tenants. That is what is going on in the country. Low detection rates, low numbers of people being charged. Even those who are detained under state of emergency preventative detention orders are not being charged after spending months in custody. And of course, the low conviction rates in comparison to all of this. Further than all of that.
I rise on standing order 46.1, relevance. The relevance of the continuation of the SOE conversation. Yeah. Relevance.
Yeah, I think you should, let's stick to, you're going off on another subject matter, even though it is, to some extent, you could stretch it. But let's come back to the essence of what we are dealing with. So I sustain that point. Move forward.
Thank you very much, Mr. President. So the point is that this is against the backdrop of all of that that's happening. The government is today saying, well, don't worry with that. By this bill, let's give the convicts the opportunity to spend less time in jail. And again, to come back to the Honorable Minister of Defense, he said, jail is the absolute last resort. Those were the words used by the Minister of Defense. That is an about turn on the hardline position of the Prime Minister. So that this bill is a demonstration against the backdrop of all of that I've just said, that my learned friend says is irrelevant to a crime bill, to a sentencing bill, literally. Against the backdrop of all of that, there is no clear policy directive. There is no calculated approach to national security, no sensitivity to the plights of victims of crime, no sensitivity to the thousands of businesses that cannot operate without spending hundreds of thousands of dollars on crime prevention equipment, security, reduced hours of operation. And after all of that, still having in some circumstances to pay extortion and protection money. So the question I ask the government today on this bill, Mr. President, is how can you on the one hand say that things are so bad, we need the SOE, and on the other hand, find that it is timely and appropriate to come to the Senate to introduce an option for reduced sentencing for convicted criminals, or according to the Honorable Minister of Defense, absolute last resort is jail. I will stop on that point and say that for the next 4 years, every day is the 1st of April in this country under this joke of a government. Mr. President, we heard about the plans. The Honorable Minister of Defense spoke extensively about the plans, the crime-fighting plans. 10 years now, 11 years now, they have plans. This bill, they told us, is part of that plan. We all know what the plan pitch sounds like. The public knows what to expect when the government wants to sell them a dream, because that is what they have to sell, Mr. President, dreams. So I ask all of the right-thinking citizens from the Senate this evening, is this what you expected from this government? Is this in keeping with the plan to fight crime, where a minister stood up in this Senate and said jail is the absolute last resort? National security and criminal justice reform, as this bill is declared to be part of, requires the government to communicate a clear, structured plan to the people. One that considers and meets the realities of the current situation, one that makes assessments and predeterminations about the future situation, and one that takes steps in a prescriptive way to address crime sustainably. But we continue to see the wild man antics, Mr. President. So I suggest before we study to release the convicts early, I think we should study to figure out how to catch the criminals who are outside in the first place. Figure out how to first detect crimes. how to buy mosquito repellent so that officers could stake out criminals and make arrests, how to support, equip, and tool police officers to have more prosecutorial competence, how to collect and preserve evidence, how to meet court deadlines on time so matters are not thrown out when documents are not filed or complainants do not come to court. Study how to support state prosecutors, how to secure them and their families better so they could do their jobs without fear. Study how to give support to victims of crime, how to protect witnesses. And when I spoke earlier about that 11-month-old child being the victim of a shooting, I have read, it is alleged, that the child's father was a witness in a crime. That is what we should be focusing on. We call on the public all the time to say something if you see something, but we are here making law about how to release convicts early. Mr. President, before we study and talk about how to release convicts, we should be studying how not to have a minister in cabinet who has pending charges against him. That type of conduct sends a clear message to every young person in this country with aspirations to leadership and public service that it is okay to have been charged twice with multiple offenses and sit as a minister in cabinet.
Mr.
Apparently that is
I
okay.
rise on 46-1.
Senator Boodhu, I think that you're going totally off course. Just stick to what is before us and not go. You're going all over the place, and the bill is specific. Please, I think you're bordering on irrelevance. So please, I'm guiding you. Just either bring your try your best to deal with relevance, please.
Thank you very much, Mr. President. I'll take your guidance and come right back to the bill. The bill says that the court can consider ordering someone on a probation order to remain employed. I have a question. Employed where? Today, while we're sitting in the Senate, the Shogunas vendors being removed by bulldozers from the Shogunas market. The Trinidad and Tobago Police Service just suffered a major evidential loss and potentially a multi-million-dollar civil litigation exposure, where a bushfire caused an entire impound lot with hundreds of vehicles owned by members of the public, not state vehicles, to be burned. So that in respect of this requirement to remain employed, maybe it might be a good idea to have kept CPEP up and running so that bush would not cause the bushfire.
Mr. President, I stand on 46-1. The debate is not about employment or SOE.
Yes. Senator Boodhu, I understand what you're trying, what you're doing, right? But please, you're crossing certain boundaries, and I'm asking you to be relevant to the bill. And I don't want to ask you to reconsider your line of thinking and debating at the moment, but I'm giving you another opportunity to be relevant, because I sustain the point made by the Honorable Senator.
Thank you again for your guidance, Mr. President. With your guidance, Mr. President, I will choose to wind up at this point in time. Now, there was an issue raised as to the belonging of this bill to a suite of other pieces of proposed legislation, and in particular, the parole legislation that is before the other place. And we've heard an explanation or an attempt at an explanation from the Honorable Minister of Defense as to why it wasn't brought together with this bill, and what he said is that he made reference to clause, permit me a moment to get the clause 2 of the bill, which says an act comes into operation, the proclamation clause of the bill, Mr. President. And in making reference to that, what he was suggesting is that this bill that is being debated today is going to be proclaimed at some later time, presumably when the parole legislation is also proclaimed or put into effect. But, Mr. President, that leads us to conclude inescapably that it is an admission that the two are inextricably linked and ought to have been brought together, because what the Honourable Minister of Defence is saying is that they will proclaim the both together. And that's because, Mr. President, parole and the amendments brought by this particular bill are almost the same thing anyway, because in the parole system, the convict can apply to be released on a probation.
Standing Order 49, Mr. President. He's anticipating he's going on to
I want to sustain that as well. So I think you say we're going to wind up. I think you should do that. Please.
Thank you, Mr. President. I will wind up and I will leave it alone, except to say that I didn't anticipate. I was saying what parole is. I don't think that is anticipatory. I think everybody knows what parole is. Mr. President, I will wind up by saying this probation amendment is speculative in nature. It asks the court to make a determination of what may happen with the accused in custody serving a reduced term before coming out from the outset of sentencing, different to the parole in that regard. But the bill is not completely as useless as the government, but it is very poorly constructed. It is lazily drafted. It contains errors. It does not take into account major factors. It has operational problems. The timing of it is out of place and tone deaf, and contrary to any victim's rights and witness protection enhancement in the criminal justice system. It adds no confidence to the prosecutorial and crime-fighting subsections of the criminal justice system. So, Mr. President, I close by asking this government to look more carefully when drafting the laws that impact upon each and every citizen of this country. And that at all is not an indictment on the learned minister piloting this bill, for whom I have a great deal of respect as an attorney at law. I ask that you be consistent, and this is for the government. I ask that you be consistent with your approach to national security, that we do not, while saying we need to jail people without a warrant, also say that we should be freeing convicted persons, which to me is blowing hot and cold at the same time. My suggestion, respectfully, is to settle in one direction and lead the country with some clarity and consistency, and remember that timing is important, but this bill is out of timing. Finally, as I join my Hindu brothers and sisters in celebrating Hanuman Jayanti today, I am reminded to take the opportunity to say that all of us have obligations to the people of Trinidad and Tobago, which require us to have strength, resolve, and courage to do the right thing in the interest of selfless service. But if you find yourself wavering, repent of your sins and turn to God. I thank you very much, Mr. President.
The Minister of Justice.
Thank you very much, Mr. President. After hearing my learned friend, Mr. Boodhu, this passionate contribution, Mr. President, when we assumed office, we were continue to be faced with a critical situation with crime. We have to employ all measures working at the same time to deal with the crime situation. The state of emergency that we have implemented has brought remarkable results the first time. It's continuing to bring results. Whilst we do that, Mr. President, we must fulfill our obligations to the society at large.
Honourable Minister, we have a procedural motion that we have to deal with. I'll call on the Minister, the Leader of Government Business.
Thank you, Mr. President. Mr. President, in accordance with Standing Order 14.5, I beg to move that this Senate continue to sit until the completion of the business at hand.
Honourable Senators, the question is that the Senate continues to sit until the conclusion of the business at hand. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The Senate will continue to sit until the conclusion of the business at hand. The Honourable Minister of Justice.
Thank you very much. Having said that, Mr. President, we must be mindful to take steps to effect a transformation in the mindset of this country. What learned senator was focused on, Mr. President, is a mindset focused on retribution. That kind of mindset creates a resistance to rehabilitative and restorative justice programs that this government intends to implement. We have tried retribution our entire life in this country. Where has it reached? Where has it caused us? We have the highest crime rate in the history of this country. In 2024, 625 murders. And you are still talking about this retributive approach? You cannot see the wisdom in having this rehabilitative, restorative step that we have taken to try to change the mindset, not only of the general public, but of criminals. They are the ones that we are reaching out to. They are the ones we are trying to change. As we would say, brother, have a heart. Have a heart. I'm harkening back to my learned friend, Mr. Faris Al-Rawi, Senator Faris Al-Rawi. A lot of his contribution was focused on victims' rights. Mr. President, under 74L of the amendment, the court can order impact statement. Further, we are going to pass a victims' right legislation. We have said that over and over. The victim, at the time of making his report, at the time of investigating the report, at the time of the case being tried in court, and at the time of after sentencing, the victim becomes important. Every single right that the victim has is going to come forward. It will include victim rights, but right now, under L4L, the court, in the interest of justice, can order a victim impact statement. So the victim is not left out at all. So I just want my friend to consider that. The other point he raised, Mr. President, he said that the Criminal Justice Unit took the place of the Penal Reform and Transformation Unit. Now, that is partly true. That is partly true. I gave a history of the Penal Reform and Transformation Unit, Mr. President. It was created by a cabinet note in 2004. The core terms of reference of this PRTU, there were 31 comprehensive recommendations that that unit had to implement. The core terms of reference was: 1, prepare an implementation schedule for the task force report on prison reform and transformation. 2, review and draft legislation to implement a restorative justice philosophy, a reintegration penal policy, and community corrections. Now, that is what the CJU took over, to review and draft legislation. All the other terms of reference, for example, to collaborate with all relevant ministries, departments, and agencies to ensure an integrative approach. Ensure restorative justice principles are incorporated into the youth justice system and adult courts. Address the physical and social infrastructure needs of correctional facilities. Monitor and evaluate project implementation. Improve the level of confidence in the criminal justice system. Improve legislative policy infrastructure. Well, maybe the CGU is dealing that. Improve the restorative capacity of criminal justice system agencies. Improve public safety and reduce fear of crime. Improve the capacity of the Trinidad and Tobago prison service to manage change. The CGU wasn't dealing with all of that. This unit that was created, that was staffed fully, was behind all of these changes in the penal reform system. Today it only has one person. Only one person. So how can you tell this honorable House that the CJU was dealing with all of these issues? Right now, the prison service has its own rehabilitation programs, but it's very limited. Without the oversight of a national unit, it is not going to be effective, it is not going to be efficient, and therefore that is why we are saying we are going to revitalize this unit to ensure penal reform is taken at its best. Now, Senator Murray gave a quite comprehensive report on the probation department and made some comments about the terms of service of children probation officers and community service officers. Now, Mr. President, as I sat here today, I signed a note for Cabinet for the continued re-employment of 21 probation officers. It was brought to me a short while ago and I signed it, but I will give you the history why I signed it. When the Children's Court was established in 2016, the services were provided by the children probation officers, whilst the community service officers were guided by the Community Service Act of 1997. Now, these two acts caused probation officers to be created to report directly to these courts. The matters were sent for the CPO to put it and to establish terms of reference. To date, the CPO has not done so. To correct that situation, Cabinet on numerous occasions has had to make certain decisions to employ these officers on short-term basis. 3 years by 3 years, and when those terms came to an end, to employ them on short-term contracts of 3 months. That is why, Senator Murray, these officers have not been implemented into the system. That is why they are not permanent employees. It is not for want of trying. We inherited that system. We have now asked the CPU again to please consider this situation so that these officers can be incorporated into the public system. Right now, they are on contract. I have asked Cabinet today to enlarge or to continue the contracts for a further 3 years by 3 years, these officers, so at least they would have something in their hands. Thank you very much. So we are dealing with this situation. Now, I know you are talking about capacity. Senator John Bates talked about capacity as well. When we pass this legislation, there is going to be the need for more officers. Indeed, there is going to be the need for more officers. We are in constant contact with the probation department. If the probation department tells us, the Ministry of Justice, we need 10 more officers, we need 15 more officers, we are going to take a note to Cabinet to get those 15 officers. Whilst we do that, we are going to ask the CPU to properly what they call establish them within the system. So there is capacity and there is the intention of the government to fulfill the implementation of this program. There's been talk about this, the point about steady employment. That clause that we have introduced in the legislation. Now, we didn't pull that out of the air. This was a recommendation from the Probation Services Division itself. They followed the U.S. Code of Laws Title 18, Crimes and Criminal Procedure at Section 3563B4. And that says it is a discretionary provision, as it is in this case, a discretionary provision that a probationer must work conscientiously at suitable employment. That is the U.S. Wording. We took it and we put steady employment. Of course, it's optional for a court when you consider the circumstances of the probationer, whether they would want to impose that. But it's an optimal state, and we are giving the court the possibility of making an order with regard to employment. That is all we're doing. It's not a must. It's one of the things that they will consider when making such an order. With the question raised by Senator Janelle John Bates on the question of, and I think Senator Faris Al-Rawi, the question of the aggregate with regard to the sentencing, we recognize that as a drafting error, and we will be making the necessary changes at the committee stage to make an amendment with regard to that. With those few words, Mr. President, I beg to move.
Honorable Senators, the question is that a bill entitled An Act to Amend the Probation of Offenders Act, Chapter 1315, and for other related matters be now read a second time. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clerk.
A bill entitled An Act to Amend the Probation of Offenders Act, Chapter 1351, and for other related matters.
Minister of Justice.
Mr. President, in accordance with Standing Order 66-1, I beg to move that the Probation of Office Offenders Amendment Bill 2026 be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honorable Senators, the question is that the Probation of Offenders Amendment Bill 2026 be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favor say aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. Senators, we have, may I have your attention? May I have your undivided attention? We have amendments, and we want to make sure each senator is in possession of those amendments. We have amendments by Senator Faris Al-Rawi, SC. We want to ensure that all members would have those amendments, either in hard copies or on your system, electronically that is. And then the government has amendments as well. And we also want to ensure that all members would be in possession of those amendments from the government to ensure that those amendments from both Senator Al-Rawi, SC, and the government, through the AG, are firmly in possession of colleagues. I propose that we take a few minutes to ensure that those amendments are properly in hand, and I'm therefore proposing that we suspend and we resume at 8:10 p.m. So this committee is suspended until 8:10 p.m. Are members ready? AG? Well, we have 15 clauses, as we all are aware, in this bill. And the first 3 clauses, we have no amendments to the first 3 clauses. So we'll take those collectively, and then we shall proceed thereafter with the other clauses. Of course, AG and Senator Al-Rawi will advise accordingly at the appropriate time. So let's proceed.
Clauses 1 to 3.
The question is that clauses 1 to 3 stand part of the bill. The question is that clauses 1 to 3 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 3 now stand part of the bill.
Clause 4.
The question is that clause 4 stand part of the bill. I think that we, Attorney General.
Chair, during the break, Senator Al-Rawi and I spoke about his amendments. It is beginning at clause 4, but continuing throughout the bill to clause 12. There are 7 pages of proposed amendments. I told him that I could undertake only to study the amendments tonight, but not to take any of these on the floor. And that given the general spirit of the debate, that it was my view that we could, on that basis, proceed with the bill as it is drafted, subject to the one change that the government proposes.
Thank you, Mr. Chairman. I thank the Honourable Attorney General for accurately reflecting our discussions. Mr. President, I have tabled many amendments. I firmly accept that the AG is proper in saying that he would need policy considerations to be discussed before he could accept these. That's a very responsible approach for any Attorney General to take, and I support that view. The purpose of my amendments, therefore, would be whether I would pursue them or not. I don't propose to pursue them for agitation for inclusion today. I wish simply to put them for the record. I'm very comfortable with the Attorney General undertaking to consider them because he wouldn't have the space to form the policy on them tonight. So if I could make life easy by having the amendments read, I would just give a very quick, short explanation as to why it is. The reason that I do this is that it will save us when we come to other matters that are yet to be anticipated, other bills, because they resonate with a certain package of laws that are to come. So I propose to make, with your permission, a very short measure of it, quick reference to the clause as proposed to be met, give a very short explanation as to what it is. I accept the Honourable Attorney General's views on the matter, no doubt the Minister of Justice as well, and that way we can perhaps dispatch with things very quickly.
Attorney General?
That's acceptable to the government, Chair.
Senator Al-Rawi, proceed, please.
Mr. Chairman, I propose to amend Clause 4, which amends Section 2 of the bill by including in the definition the word ammunition, the word prohibited weapon, the word pepper spray, the inclusion of the word relative, the word victim, etc., largely so that they would resonate with other proposals in the law which I recommend for consideration, and that is that we introduce mandatory victim impact statements, we introduce pepper spray, ammunition, and prohibited weapons in the class and category of things that you're prohibited from holding whilst on probation. We also include inside of that no objection to the government's proposed amendments on that. That's the rationale for Clause 4 as proposed to be amended by me.
question is, we now proceed to clause 4. The question is that clause 4 stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 4 now stands part of the bill.
Clause 5.
The question is that clause 5 now stand part of the bill, or stand part of the bill. I think that we have another intervention by Senator Al-Rawi.
Yes, Mr.
Based
Chairman.
on his amendment.
Thank you, Mr.
And then we
Chairman.
also have an amendment by the Minister of Justice.
Yes, sir.
Yeah.
Very quickly, the proposals for the amendment to clause 5 are specifically first with respect to section 3(1), that we remove the language from the parent law that you are in a summary court and you instead go with the phraseology, you're charged with a summary offense. We introduce into that the interest of justice requirement, and you also introduce specifically that an impact on the victim is to be undertaken by the court. That would open the door for the impact statement. That then echoes to harmonize with the amendments to subparagraph 2 of the section, again adding the interest of justice and the victim impact statement. In the mandatory use of the statement, it's proposed that section 3(3), which this clause would amend, would include that before you make a probation officer, that you not only do an assessment of the offender, but you also have a victim impact statement. In keeping with that philosophy, it is intended that the victim impact statements, do's and don'ts, are taken on board. That is what the victim impact statement should contain, and not contain the prohibitions against characterization and restatement of facts, accused, etc. That the court would have the liberty to have the victim impact statement read by the victim or by a relative of the victim, and in the circumstances where a child is involved, by persons qualified to act on behalf of the child. It also proposes to include as a category of victims a business, and that the prosecutor takes certain positive steps to keep the victims informed, and that the court then makes its decision there. This, I could flag, would come up in considerations when we get to parole, just giving a little heads up on that, so perhaps the considerations can extend when that bill eventually comes. Thank you, Mr. Chairman.
Okay, thank you.
It also includes the the Minister of Justice's very amendment that he has tabled, which is that we use the longest of the terms when we're dealing with consecutive sentences, but the Minister of Justice has captured that in the amendment he has proposed. Thank you.
The Minister of Justice, you want to just explain 5A?
Chair, we propose an amendment to take into account some concerns which were raised with respect to the drafting in the course of the debate. It's circulated.
Okay.
We are in agreement with it, Mr. Chairman. The proposed amendment is to take away the calculation clock and to put it in line with where you have concurrent sentences, that you use the longest of the concurrent sentences and not the aggregate of those sentences.
The question is that clause 5A be amended as circulated. Those in favor say aye. The question is that clause 5A be amended as circulated by the Minister of Justice. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. Clause 5A. The question is that clause 5A, as amended, now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 5A, no. Question is that clause 5, as amended, now stand part of the bill. Those in favor say aye. Those against say no. Clause 5A, as amended, now stand part of the bill. Let's go.
Clause 6.
The question is that clause 6 stand part of the bill.
Mr. Chairman. Thank you, Mr. Chairman. Mr. Chairman, I propose an amendment to Clause 6. Clause 6 amends Section 4 of the Parent Act. We agree with the government's amendment that we move from 3 years to 5 years for the effective management of probate, but we flagged for the government that there is a probable consequential need to amend subsection 2. So instead of 12 months, that you go to a larger term, which is 24 months. That's one of the reasons inside of there. We also propose, Mr. Chairman, in subclause 3 of the Parent Act, that where the court order is made, a probation order is made, currently it says you furnish 2 orders, one to the probationer and one to the probation officer. We are proposing, in keeping with the victim impact and the use of a register of offenders, that you provide a copy of the order to the Commissioner of Police, to the Chief Probation Officer, and to the probationer and the probation officer. So that is intended to take care of the introduction of a register of probation offenders. Probationers, that's the word. Thank you, Mr. Chairman.
The question is that clause 6 stand part of the bill. The question is that clause 6 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 6 now stands part of the bill.
Clause 7.
The question is that clause 7 stand part of the bill.
Mr. Chairman, if I may, on clause 7, it appears in other places, but I'll flag it now. We have in the bill in clause 7 sought to remove the word summary, and I would invite the Attorney General's office to have a look at the other places in the parent law where the word summary is used. You'll find that those need to be removed as well, because we're now dealing with a different form of access to the courts. So you'll see it in several sections where the word summary is flagged.
Okay. The question is that clause 7 stand part of the bill. The question is that clause 7 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 7 now stands part of the bill.
Clause 8.
The question is that clause 8 stand part of the bill. Senator.
Thank you, Mr. Chairman. Clause 8 we propose to be amended. That amends Section 7 of the Parent Act. We are proposing that there be closer regard to the word summary appearing here. This is one of the places where it ought to be reconsidered. And then if you look as well at the use of $300 and the fine moving upward, we propose that the court be allowed in its discretion to fix the fine, so that that would in fact not come up with a too low a fine, particularly where the Interpretation Act can act, but it gives the court the room where summary offences may be non-financial, where maybe financial crimes, non-blood crimes, they may be severe, and you'd find that the $3,000 is not an adequate sum in terms of recommendation. We also propose, Mr. Chairman, that it's here that there's a mandatory insertion of a registration requirement for the Commissioner, with the Commissioner of Police, to be on what we propose is the inclusion of a national registry of probationers. We also here in this clause propose in paragraph K that we go beyond the word firearm and we harmonize it with ammunition, prohibited weapons, and pepper spray. That would be in keeping with what will come in the parole law. And the last one is in paragraph L, that we include more than just the good conduct of the offender, but we include in the interest of justice. Mr. Chairman, if I could say this, the reason that we're proposing these, even though there's a proclamation clause, there will come a point when there's a collision between the offender's law and parole law when you go to split sentences. So something is going to have to go in the future That's what the harmonization attempt is intended to address here. Thank you, Mr. Chairman.
Thank you. The question is that Clause 8 stand part of the bill. The question is that Clause 8 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 8 now stands part of the bill.
Clause 9.
The question is that Clause 9 stand part of the bill. Senator Faris.
Thank you, Mr. Chairman. Mr. Chairman, Clause 9 proposes an amendment to Section 9 of the Act. Section 9 is the commission of further offences by probationers. It's here that we propose that you don't await conviction, that at the moment that you're charged whilst being a probationer, that you go back before the court, and we include here the ability that the court may revoke or vary in the interest of justice the order it has made. It keeps the conviction where everything falls apart later on, but it's at this point where we put in charge so that it's as a condition of your probation, you find yourself in trouble with a further charge. The minute you're charged there, you're brought back to consider the probation that you're under whilst under charge. It would harmonize with the Bail Act. Thank you, Mr. Chairman.
The question is that Clause 9 stand part of the bill. The question is that Clause 9 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 9 now stands part of the bill.
Clause 10.
The question is that Clause 10 stand part of the bill. Senator Faris Al-Rawi, SC.
Thank you, Mr. Chairman. Mr. Chairman, Clause 10 amends Section 10 of the Act. It is here that we make the proposal that the government have a look from a policy perspective at moving beyond $5,000 if you found yourself in breach with probation. The summary offences are much higher. We are proposing anywhere between 50 to a higher sum, 50,000 to a higher sum, depending upon what matrix for punishment is revealed, bearing in mind that summary and indictable offences may be of a very serious nature or high-value offences, and this may be inadequate. Thank you, Mr. Chairman.
The question is that Clause 10 stand part of the bill. The question is that Clause 10 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 10 now stands part of the bill.
Clause 11.
The question is that Clause 11 stand part of the bill. Senator Faris Al-Rawi, SC.
Thank you, Mr. Chairman. Clause 11 proposes an amendment to Section 13 of the Act, where we're moving from 3 years to 5 years. We believe that insofar as that ceiling is being raised, that the residency period of 12 months in the existing law ought to be reconsidered and moved upward from 12 months to a higher value, perhaps 24 months. That would assist us in getting to the position of balance with the previous amendments that we have proposed. I should add, Mr. Chairman, that there's a little connection to Section 12 of the Act, where we're asking for charge and conviction to be considered, not only conviction. Thank you, Mr. Chairman.
The question is that Clause 11 stand part of the bill. The question is that Clause 11 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 11 now stands part of the bill.
Clause 12.
The question is that Clause 12 now stand part of the bill. Stand part of the bill, rather. Senator Faris Al-Rawi.
This is the last proposed amendment for consideration. Mr. Chairman, we agree with the proposal for the sealing and application to seal the court record. We propose that the government consider that we take another step, which is that the person may apply for the criminal record to be expunged. If you go to Section 51, 52, 53, or somewhere around there, or 50A of the Police Service Act, you will see that the criminal record is kept indefinitely, and those things appear in a certificate of character. Bearing in mind that the public procurement law requires that you have a clean certificate of character, you're going to find a host of people that can't qualify in public procurement. The process of expunging your records by an application to the Commissioner of Police, precedent can be found in the amendments to the Dangerous Drugs Act for the cannabis that we had done, but also this would give a positive obligation of the court just telling the police expunge it as opposed to going through the process of having to get it done. So that's the rationale behind this. Thank you, Mr. Chairman.
The question is that clause 12 stand part of the bill. The question is that clause 12 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 12 now stands part of the bill.
Clauses 13 to 15.
The question is that clauses 13 to 15 stand part of the bill. The question is that clauses 13 to 15 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses 13 to 15 now stand part of the bill.
New clause 6A.
The question is that new clause 6A be read a second time.
Mr. Chairman, this, without even need to go for its vote on it, it's just to advise that we should look at harmonizing, eliminating under the age of 18 and just using child, because we've done that in a host of other laws. Thank you, Mr. Chairman.
The question is that
Question? New clause 6A be read a second time. Huh? Those in favor say aye. Those against say no. I think the noes have it. Yeah.
New clause 10A.
The question is that new clause 10A be read a second time.
Mr. Chairman, this was already addressed, so we wouldn't read it again. Thank you.
Okay. Those in favor say aye. Those against say no. I think the noes have it. Honorable Senators, the question is that the bill as amended be now reported to the Senate. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The bill as amended will now be reported to the Senate. Justice.
Mr. President, I wish to report that the Probation of Offenders Amendment Bill 2026 was considered in Committee of the Whole and approved with my amendment. I now beg to move that the Senate agree with the committee's report.
Honorable Senators, the question is that this Senate agree with the committee's report on the Probation of Offenders Amendment Bill 2026. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The Minister of Justice.
Mr. President, I beg to move that a bill entitled an act to amend the Probation of Offenders Act, Chapter 13, 15, and for other related matters be now read a third time and passed.
Honorable Senators, the question is that a bill entitled An Act to Amend the Probation of Offenders Act, Chapter 13, 15, and for other related matters be now read a third time and passed. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Division.
Mr. Allaha,
Yes.
Mr. Jeremy Essie, Mr. Roberts,
Yes.
Dr. Swarat Singh,
Yes.
Mr. Maharaj,
Yes.
Mr. Batiste,
Yes.
Mr. Alexander,
Yes.
Mr. Ratiram,
Yes.
Professor Prasad,
Yes.
Dr. Chaita Maharaj,
Yes.
Ms. Charles,
Yes.
Mr. Zakur,
Yes.
Mr. Smith,
Yes.
Mr. Naked,
Yes.
Mr. Rashid,
Yes.
Dr. Brown,
Yes.
Mr. Al-Rawi SC,
Yes.
Mr. Dan Paul,
Yes.
Mrs. John Bates,
Yes.
Mr. James,
Yes.
Mr. Boodhu,
Yes.
Dr. Atz,
Yes.
Mr. Delabastide SC,
Yes.
Mr. Lewis,
Yes.
Dr. Murray,
Yes.
Mrs. Lilith Etienne,
Yes.
Mr. McNish,
Yes.
Mr. Gibbings, Dr. McPhee,
Yes.
Mr. President, the results of the division are as follows. 29 senators voted for, there were no senators voting against, and there were no abstentions.
Honorable Senators, may I have your attention undivided? Honorable Senators, the result of the division is as follows. 29 members voted for the bill. No member voted against the bill, and there were no abstentions. The bill has been unanimously approved.
To amend the Probation of Offenders Act 1951 and for other related matters.
The Honorable Leader of Government Business.
Mr. President, I beg to move that the Senate do now adjourn to a date to be fixed.
Honorable Senators, before putting the question on the adjournment, or the motion rather, I would like to advise that leave has been granted by the Senate for a matter on a motion for the adjournment to be raised by Senator Dr. Amory Brown. Senator Amory Brown.
Thank you very much, Mr. President. Mr. President, the previous cabinet of Trinidad and Tobago approved this country's candidature for a non-permanent seat on the United Nations Security Council for the period 2027 to 2028. And we understand that this has since been reaffirmed by the current government and cabinet of this country. Mr. President, the election will be held at the UN General Assembly in June of 2026, which is quite soon. Before the last general election, we presented at COFCOR and advocated with CARICOM based on our vision and ethos and principles that we would adopt at the Security Council if we got CARICOM support. And we did achieve a CARICOM endorsement of the Trinidad and Tobago campaign with the understanding that we would take the voice of CARICOM with us to the United Nations Security Council. Back in 2013, our permanent mission signaled to GRULAC a placeholder intention to seek election for the 2027-2028 period. That is the accurate record between the two administrations. So, Mr. President, let's talk about the United Nations Security Council. There are 15 members of the UNSC, 5 permanent members who each have veto powers: China, France, Russia, the United Kingdom, and the USA. And then there are 10 non-permanent members who are elected by the UN General Assembly. So what does it do? The responsibility of the United Nations Security Council is the maintenance of international peace and security. The maintenance of international peace and security. The council, that council, takes the lead in determining the existence of a threat to peace or an act of aggression and calls upon parties to a dispute to settle it by peaceful means. The Security Council can impose sanctions or binding obligations, and it can authorize the use of force to maintain or restore international peace and security. Note those words, Mr. President. Not might is right or a random country can make those decisions. It is the Security Council that has that authority, and only the Security Council. In that regard, Mr. President, can our responsibility on the Security Council be fulfilled whilst the Ministry of Foreign and CARICOM Affairs of this country puts out bulletins giving support within hours for the bombing of another sovereign state? It's a serious question. Or supporting an attack, killing the entire leadership of another sovereign country prior to even the declaration of war. Nobody asked a question, but Trinidad and Tobago put out a public release voting yes to a war. Can Trinidad and Tobago fulfill that mandate at the Security Council whilst openly supporting unilateral sanctions against the Republic of Cuba, which violate international law? Can this government fulfill that mandate while they are so officially
Mr. President,
silent
46-1
on
is
Gaza?
that, Mr. President. Mr. President, 46-1, the matter on the adjournment is very narrow. It is very narrow.
Two of you all can stand at the same time. Are you on a point of order?
46-1, the matter on the adjournment is a very narrow motion.
I know he has 10 minutes and so on. Continue.
Mr. President, I draw on your experience, Mr. President, in these matters. I will continue. Mr. President, can Trinidad and Tobago fulfill that mandate when this current government cannot even reaffirm its commitment to the UN Charter? It cannot reaffirm its commitment to the UN Charter.
Mr. President, I rise
and
again,
it stands on
46-1.
international...
You have to rule.
I asked the question about these matters on the motion for the adjournment, because they are not identified in terms of points or bullet points or people, there's some element of elasticity, but I ask that the minister who is responding to this motion is quite adequately placed to address those issues. Continue.
Thank you for overruling the interruption. Mr. President, the minister is quite capable of doing so. So, let me repeat the question. Can this government fulfill that mandate when they are unable to reaffirm commitment to the UN Charter and international law in response to a question in this very Senate posed by Senator Vieira? Can this government fulfill that mandate at the Security Council when we are silent on illegal sanctions imposed on the ICC prosecutors and other officials of the International Criminal Court? Just because that court has the audacity to try to hold President Netanyahu to account for atrocities in Palestine. Mr. President, David Rudder asks a question in his iconic song, Rally Around the West Indies. Does this world need small islands anymore? In our opinion, this world does need small islands because it needs our voice, our unique voice, our sovereign voice, our principled voice, even at the level of the United Nations Security Council. It needs us to be brave, it needs us to be clear, it needs us to be principled, it needs us to defend sovereignty, not be mere vassals of another voice. It needs us to have a unique voice, to carry the voice of CARICOM, to carry the values of CELAC, to carry the values of the OAS into corridors where the others may not have access. To speak for the victims of war, not for the perpetrators of war. To speak for the victims of apartheid and genocide, not for the perpetrators. This is not anti any nation, Mr. President. This is pro-justice and pro-humanity. Mr. President, if we can agree that blessed are the peacemakers, we have the opportunity to be blessed as peacemakers. We must acknowledge the need to approach a seat at the United Nations Security Council to carry a strong anti-war and pro-international law agenda, not the other way around. Mr. President, our voice at the Security Council, which we support and we want to succeed, that voice will be wasted and squandered if it is a voice of geopolitical convenience. Our voice must be the voice of international peace, of the universal application of international law, without any carve-outs for big powers. Mr. President, the only reason we should be there at this highest forum for international peace and security is if we sincerely want to make the world a better place. That's the only reason. Always, Mr. President, we wish the best for the Republic of Trinidad and Tobago. We support our success with respect to the election for the United Nations Security Council. But we thought it prudent and important, given the government's relative silence on this campaign, to put some principles on the table and request a response from the government. Mr. President, I thank you.
The Honourable Minister of Foreign Affairs and CARICOM Affairs.
Thank you, Mr. President, for allowing me to respond to this motion that was brought by Senator Brown. It is my first time being back in this August chamber, and I've spent a considerable amount of time here before, and it's very, but I wouldn't give up my seat. Mr. President, before I get into my contribution to apprise not only this August chamber, but the country as it pertains to the work that the Ministry of Foreign Affairs has been doing to advance our campaign for a non-permanent seat on the United Nations Security Council, I will just touch on a couple of the issues raised by Senator Brown, especially as it pertains to the amount of time that we have with respect to these motions. I want the country to understand, especially based upon the admissions and the contributions made by Senator Brown concerning messages as it pertains to Iran or Cuba and the positions of Trinidad and Tobago with respect to our relations with the United States. We make no apology as it pertains to our relationships with the United States. Adopting a position against narco-terrorism and narco-trafficking, condemning it at the strongest possible multilateral event such as United Nations General Assembly. What could be wrong with a position like that? Are we to then be on the opposite side or the opposite side and say, yes, we have no problem with a plethora of drug boats coming into the country. We have no problem with a plethora of guns coming into the country. And so to say then that we support the US's military intervention to deal with those things that have been perpetrated for 10 years under previous administration, I could see absolutely nothing wrong with that as a position to be adopted by a responsible government. The honorable member spoke about small island states. We are quite aware as to what responsibility we have being a small island state, being an advocate for SIDS on the whole and in general. And we will continue to do that as a member of the Non-Permanent Security Council. And any talk that is being peddled about apartheid and genocide, it is the Honorable Kamala Persad-Bissessar in her first term as Prime Minister that was the person that brought to CARICOM discussions on reparations. And I would remind this House and this country about that. So when persons sit and speak illustriously about a number of things that clearly they are unaware of historically, it's a shame because it has the unfortunate circumstance of misleading this country. And I would hate to think that my learned friend on the other side would even attempt to do so by moving such a motion in this honorable chamber. Mr. President, the honorable senator was correct insofar as he said, pursuant to Cabinet Minute 401 of March 6, 2025, approval was granted for Trinidad and Tobago to pursue a non-permanent seat on the United Nations Security Council for the period 2027-2028. The elections are scheduled to be held on June 3, 2026 at the United Nations headquarters in New York. And it is noteworthy that Trinidad and Tobago previously served as a non-permanent member of the Council in 1985. Mr. President, you may wish to also note that 63 years ago, as a newly independent nation, Trinidad and Tobago joined the United Nations. As a member of the UN, we have adhered to the charter of the body, unlike what has been said previously. Trinidad and Tobago appreciates and recognizes the magnitude of the responsibility bestowed on the Security Council. And for small states like Trinidad and Tobago, the maintenance of an international rules-based order and security is of paramount importance. It is the government's primary view that we can only be better together if we confront complex and evolving global issues head-on instead of burying our heads in the sand. Further, the Honorable Kamala Persad-Bissessar, SC Prime Minister, has emphasized that Trinidad and Tobago will always, and I repeat, will always come first under her leadership. As we focus on addressing the country's challenges, it is in this context that Trinidad and Tobago is committed to using its seat on the UNSC for the advancement of the interests of the people of Trinidad and Tobago, the region, and the wider international community. Once elected, we would ensure that the voices and perspective of all states are meaningfully represented in the work of the Security Council. Trinidad and Tobago is in the process of campaigning for its candidature as a non-permanent member of the UNSC for the term, as aforesaid. The areas of national priorities which will impact the role played by Trinidad and Tobago are consistent with its stated objective of respect for regional and international rule of law, security, protection of vulnerable communities, and addressing emerging threats of illicit trafficking of small arms, light weapons, and artificial intelligence. I wish to advise the Senate that as a result of Trinidad and Tobago placing emphasis on these priority areas, this country's bid for a non-permanent seat on the UNSC for the period aforesaid is currently uncontested within the GRULAC region, which is a group of Latin America and the Caribbean states. Don't look so surprised. If you have information to the contrary, you could always say. Elections for non-permanent seats on the UNSC are conducted by the UN General Assembly through secret ballot, which I suspect many of us already know. If no candidate achieves the required majority in the first round, multiple rounds of voting continue until all seats are filled. Elections are held in June, and successful candidates serve a 2-year term beginning on the 1st of January of the following year. Moreover, non-permanent members of the UNSC, which will include Trinidad and Tobago once elected, will hold the Council's presidency on a monthly rotating basis following the English alphabetical order of member states. Each presidency lasts 1 month, during which the presiding country sets the Council's program of work, chairs meetings and consultations, leads negotiations and resolution, prepares statements and manages any urgent issues that arise. Our campaign launch. In advance of the official campaign launch scheduled for May 2026, the permanent mission of the Republic of Trinidad and Tobago to the United Nations in New York successfully had a soft launch on the 13th of February 2026. This soft launch was a strategic step designed to build early momentum, strengthen relationships, and engage key partners ahead of the formal rollout. The mission continues its outreach to regional groupings and other stakeholders in support of mapping the electoral landscape, enabling the mission to assess sensitivities and secure early endorsements. Mr. President, based upon the time, I would want to also indicate that we do have CARICOM support as it pertains to this particular candidate. We also have global support of over 100 UN member states, including regional groupings. Mr. President, in closing, because of the time as well too, I would like to place squarely on the record that Trinidad and Tobago stands on a strong building blocks of cordial bilateral relations, and this country has continued to maintain warm relations with our partners, whether it be from the Orient of the Far East, the sand dunes and rich cultural history of the Middle East, the Romanesque and Gothic designs of Europe, to the Great Plains of the Americas, and lastly, but certainly by no means least, the warmth of the Caribbean and Latin America. We have adopted the clarion call of our Honorable Prime Minister to create and concretize new long-lasting friendships. It is for this reason that Trinidad and Tobago is steadfast and confident in its goal of being elected to a seat on the United Nations Security Council as a non-permanent member for the period 2027 to 2028 at the elections to be held during the 80th session in June 2026. Thank you.
Honorable Senators, Easter is here. I now invite Senators to bring greetings to commemorate Easter celebration 2026. I now call on the Minister of Planning, Economic Affairs and Development, and the Minister in the Ministry of Finance.
Mr. President, honorable senators and members of the national community, I rise today to extend warm and sincere greetings to the Christian community on behalf of the government as they enter the solemn and sacred observance of Holy Week, marking the final days of Jesus' life, his passion, death, and resurrection. May the blessings of this week extend to all our citizens, all the citizens of the Republic of Trinidad and Tobago. These holy days magnify the period of reflection, sacrifice, repentance, and renewal within the Christian tradition marked by Lent, when many of our citizens engaged in prayer, fasting, and almsgiving, examine their conduct, and recommit themselves to lives of compassion, humility, and service. Holy Week invites us to contemplate sacrifice, forgiveness, and the triumph of hope over despair, love over hatred, and new beginnings. It reminds us that renewal often comes by dying to oneself, that growth requires introspection, and that enduring progress demands moral courage. In a nation as richly diverse as ours, these spiritual rhythms do not exist in isolation. They form part of the spiritual and moral architecture of our society. We just commemorated Spiritual Baptist Shouter Liberation Day, a unique observance that honors the resilience, faith, and cultural contribution of the spiritual Baptist community. Eid al-Fitr, which heralds the end of Ramadan, the Muslim holy month of fasting, also reminds us of the profound contribution of Islamic sacred observances to the social and moral fabric of Trinidad and Tobago. The Hindu community recently celebrated Navratri, with the conquering of evil and the emergence of enlightenment, while the Baha'i community recently celebrated the hope that comes with their new year. In our plural society, the spirit of generosity, sacrifice, cooperation, and reconciliation that defines our religious observances reflect the shared principles of compassion, mutual respect, and justice underpinning our democracy. We are a people shaped by trials and strengthened by faith. We are a society where different religious traditions coexist, not in competition, but in mutual respect. Whatever our major religious feasts, our spiritual observances cultivate values that are essential to building a stable and prosperous nation: discipline, compassion, integrity, gratitude, and service. This Kamala Prasad Bisesad-led government emphasizes that national development is not only about infrastructure, fiscal policy, or economic growth. It is also about the development of character. It is about social cohesion. It is about trust in our institutions and in one another. A nation cannot sustainably grow if it neglects the moral and ethical foundation upon which progress must stand. The lessons of sacrificing today for a better tomorrow mirror the discipline required for economic stewardship. Just as individuals may fast or abstain during this season to cultivate spiritual strength, so too must a nation at times exercise restraint, prioritize wisely, and make necessary decisions to secure long-term stability and opportunity for future generations. Holy Week also speaks to reconciliation and forgiveness and new beginnings. The scripture tells us that Jesus made peace by the blood of the cross. He broke down barriers in a time when public discourse can be sharp and divisions can appear deep. This sacred period invites us to lower our voices, to extend grace, and to remember that we share a common destiny. Development thrives where unity prevails. Investment grows where stability is nurtured. Innovation flourishes where people feel respected and included. May this season of sacrifice and rebirth challenge us to ensure that no community feels marginalized, that no citizen feels unheard, that our development agenda reflects the aspirations of all our people, from rural villages to urban centers, from young entrepreneurs to senior citizens. May this Holy Week inspire us to become better neighbors, better colleagues, better citizens. May it deepen our appreciation for sacrifice and awaken in us a greater willingness to serve one another and love one another. In closing, may this sacred time bring peace to your homes, clarity to your minds, and strength to our beloved nation. May God bless us all, and may God continue to bless the Republic of Trinidad and Tobago. And on behalf of the government, I wish all of you a happy and holy Easter.
Thank you, Mr. President. Good night. And as usual, it's good to see you. Mr. President, Easter is the most sacred season for the Christian faithful. It's a time of passion, sacrifice, and ultimately resurrection. Easter is the most important feast in the Christian calendar, signifying the celebration of the resurrection of Jesus Christ after his crucifixion and death. The resurrection is Jesus' triumphant victory over death and sin, and is the core of the Christian belief. It signifies the fulfillment of God's promises, offering forgiveness, redemption, and the promise of an eternal life to believers. This is a pivotal moment demonstrating God's love and power. It is the very essence of Christian theology, turning his moment of death into his celebration of life. The resurrection of Jesus confirms everything that he taught and preached during his 3-year ministry. His resurrection provided final and undeniable proof that he is the Son of God and that he defeated sin and death. Mr. President, Easter is a time when churches across Trinidad and Tobago, from the grand cathedrals of Port of Spain to the modest prayer halls of our rural communities, will be filled with voices lifted in praise and thanksgiving. To all who celebrate, I say simply, may your Easter be deeply blessed. But the themes of Easter, renewal, redemption, and the triumph of hope over despair, speak beyond any single faith or tradition. And in a nation as beautifully diverse as ours, those themes belong to all of us. Mr. President, walk in any community this Easter weekend, and you will find families gathered, neighbors sharing, children laughing. You will find a people who have chosen to celebrate, a people who have refused to surrender their hope. That, Mr. President, is the resurrection spirit, and it lives powerfully in the people of Trinidad and Tobago. Easter is also a season of reconciliation, and I want to say, speaking not only as an opposition senator, but as a citizen of this republic, our colleagues across the aisle are not our enemies. We may disagree, sometimes vigorously, on policy and approach, but we share a common love for this country and a common hope for its future. This Easter, I extend to every senator in this chamber, government, opposition, and independent, the hand of genuine goodwill. Mr. President, permit me to extend special greetings to you, the Clerk of the Senate, and all parliamentary staff. To the citizens of Trinidad and Tobago, we on this side wish you peace and renewal. May this season remind us all that there's no situation is so broken it cannot be renewed, and no nation is so divided it cannot be healed. That is the promise of Easter, and for Trinidad and Tobago, Mr. President, that promise could not be more timely. A most blessed and peaceful Easter to all, and may God bless us all. Thank you.
Senator Francis Lewis.
Thank you, Mr. President. Good night, colleagues. Mr. President, on behalf of the independent bench, I want to extend warm and sincere greetings to all citizens of Trinidad and Tobago as we approach the Easter season and this weekend. In our richly diverse nation, this time of year invites reflection across communities, traditions, and beliefs. It's a season that, as with other seasons that we have recently celebrated, encourages us to pause to consider what it means to live with compassion, integrity, and to renew our sense of responsibility to one another. Whether observed through sacred ritual, family gatherings, quiet reflection, this is a period, as other periods in other religious traditions offer, a chance for a meaningful opportunity to reconnect with values that sustain and strengthen our society. For our Christian brothers and sisters, Easter stands at the very heart of their faith. a sacred commemoration of the resurrection of Jesus Christ, signifying triumph over death, the power of redemption, and the promise and power of divine love. It is a time of profound religious significance marked by reverence, gratitude, and hope. We acknowledge and respect the depth of this observation and the comfort, strength, and inspiration it brings to so many across the nation. At the same time, the themes associated with Easter, renewal, sacrifice, forgiveness, new life, resonates far beyond any single tradition. They speak to something universal in the human spirit, in a world, and often reflecting our world today, often marked by challenge and uncertainty. These themes remind us of enduring possibilities of renewal, the quiet strength found in compassion, and the transformative power of forgiveness. As we reflect on the season, all of us, whether people of faith or people of no religious affiliation, find space to consider the deeper meanings in our lives and our shared humanity. May we be guided by love in our interactions, by understanding in moments of difference, and by hope in times of difficulty. And may we embrace and inspire new beginnings, both within ourselves and the wider community we are called to serve. So on behalf of the bench, the independent bench, I wish every citizen a peaceful, safe, and meaningful Easter. May the season bring a renewal of spirit, kindness in our communities, and a deeper sense of connection to all of us. Thank you, sir.
Honorable Senators, allow me to join in bringing greetings on the occasion of Easter. As we mark this sacred season, I extend warm Easter greetings to the people of the Republic of Trinidad and Tobago. For Christians, Easter stands at the very foundation of the faith. The story of the suffering, crucifixion, and resurrection of Jesus Christ. It is a story that has endured through generations, speaking not only to the reality of hardship, but more significantly to the promise of hope and renewal. From the sorrow of Good Friday to the joy of Easter Sunday, we are reminded that no matter how difficult the journey, there is always the possibility of new life. Easter invites us to pause and reflect, not only on that story, but on how we live our own lives. It calls us to embrace values like sacrifice, forgiveness, humility, compassion, and faith. Values that do not belong to one group alone, but which strengthen any society that chooses to live by them. In a world that often feels hurried and divided, Easter reminds us of the quiet power of kindness, service, and love for one another. Here in Trinidad and Tobago, we are blessed with a rich mosaic of cultures and beliefs. Only recently, our Muslim brothers and sisters celebrated Eid, a time of prayer, generosity, and gratitude. Around this same period, the Spiritual Baptist community celebrates Spiritual Baptist Liberation Day and a celebration of faith, perseverance, and freedom. Now, as the Christian community observes Easter, we are reminded that across our different traditions, there is a shared call to care for one another, to give ourselves, and to build each other up. The scripture in the book of Romans speaks to living in harmony with one another, following the example of Christ. At its heart, that message is simple but powerful: to treat each other with patience, understanding, and love. In times like these, that message could not be more sacrosanct. The strength of our twin island nation has always depended on our willingness to look out for each other, to show compassion, to offer support, and to stand together, especially when it matters most. Easter also reminds us that difficulty is never the end of the story. The message of the resurrection is one of resilience, transformation, and hope. And so, as a nation, we too must continue to rise in the face of challenges with courage and conviction, and move forward with a shared sense of boundless purpose. Now let this season encourage us to act with compassion, to lead with integrity, and to play our part in building a stronger, more united Trinidad and Tobago. Honorable Senators, on behalf of the staff of the Parliament of the Republic of Trinidad and Tobago, on my own behalf and that of my family, I wish you all present and the wider population a peaceful, blessed, and hopeful Easter. Happy Easter to all. Honorable Senators, the question is that the Senate do now adjourn to a date to be fixed. Those in favor say aye. Aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to a date to be fixed.
I thought you told me 7.